program and energy assistance household
Hello,
that would
test.
lead to the conclusion if you were only looking at Good afternoon. The Commission will resume its rulemaking in docket RM 78 and docket PC 55 with respect to retail gas and electric supply offers to low-income customers. When we last met last Thursday, we made our way through a considerable portion of the proposed regulations, modifying them along the way. We will continue to do so today and pick up where we left off. However, this would be a good time to hear from our senior staff advisor just to give us a recap of where we've been and where we're going. Ms. Knoll, good morning.
Thank you, Your Honor. I have prepared an updated red line, which was circulated to the service list on Friday, and I have received a couple of emails of items that issues that have been flagged. So I just want to walk through and kind of confirm, and folks can raise things as we go. Nobody had any issues with the contract for energy assistance households definition. I believe the Office of People's Counsel wanted to briefly take a look at the energy assistance household definition. And I just want to verify for the Commission that I have included only electric on the electric side, and then I've made a conforming edit to gas on the gas side. Do you want to hear OPC's arguments now, or do you want to do the full walkthrough before we circle back?
Let's do the full walkthrough, and then we could get back to loose ends.
So the definition section is completed. I wanted to flag here in 03A, this was not originally identified as a red line, but this is totally formulaic. As I was going through the regulations, I realized we no longer require paper copies, so I've deleted that from our regulation with the Commission's approval. Okay.
Thank you.
Section 10, approving a contract for energy assistance households. I made some wording changes to what OPC had proposed to just use the same terms that we used kind of throughout. So OPC had requested that there be identification of the contract. So the terms that I used were a commitment to uniquely identify the offer in such a way as to distinguish the commission-approved contract for energy assistance households from other supply product supplier may be offering for sale in Maryland. I don't think I've changed any meaning, simply used consistent terms throughout. I have a flag here as to whether or not 2 should be moved up a level in the outline. I've spoken with General Counsel, and they had suggested that this should be moved up to a C. So with the Commission's approval, I'll change the outline structure here.
Thank you.
That'll make this modifying all the licenses, not just the form submission. I'm just going to make a note here. Moving down, if we do revisit the definition for energy assistance households, we'll need to make conforming edits.
Go for it.
Your Honor, I'm sorry to interrupt. It's Brian Green for RISA and NRG. I just want to make sure, should we be, if there's a wording issue that we want to discuss, should we be flagging that now, or are we going to come back to that, an opportunity to come back to that later?
You'll have an opportunity to come back later. We're still in the recap
Okay.
right
I
now.
just want to make sure I wasn't missing anything. I apologize.
As I said, I've received issues from some of the parties. I have not, however, been in my email much this morning, so I don't know all of them.
Okay, yeah, to the extent there was any, I mean, the commission did take informal votes on some of these items, but it sounds like there's some issues perhaps that got lost in translation. We'll revisit.
We considered whether or not energy assistance household status should be included in the pre-enrollment information. The commission determined that would be a useful tool. And then we're into transfers of service. We did a lot of work in this section. We have the automatic rejection. We have informing folks within 2 weeks. And then in here, there were a lot of wording changes, so I just want the commission to take a careful look at the wording. So we have contracts signed on or after July 1, and then a customer who later receives energy assistance. So first, the utility will send the notice, and then, again, the wording changes are mostly in the yellow highlighted. So we have within 5 business days, the supplier has 3 options, A, B, and C: terminate the contract and return the customer to SOS. And then I rephrase this. So if provided for under the existing contract, which would be the contract that was signed on or after July 1, begin providing service under a commission-approved contract for low-income customers. I'm going to just remove this hyphen while we're here. Or obtain the customer's consent to receive service under a commission-approved contract for low-income customers. And then 3, we have staff's customer protection, which is that the customer will be guaranteed at or below SOS between the notice period and when the supplier effectuates the change.
Mr. Chairman, so I understand what we're going to do, I did want to go back and ask a few more questions. After we discussed this section, I was kind of moved by Ms. Weir and Ms. Peltier's concerns over the language, and so I did want to go back and understand from staff, what we did as opposed to the original, I will call it the original straw man language. Tell me when that would be the correct time to have that discussion and that for me to ask that question.
We could revisit all of these items at the conclusion of the walkthrough. And Ms. Knoll, just as you're going through this, A, B, and C, that was the OPC proposal,
Correct.
and 3 was from staff.
Correct.
Thank you.
And the combination of the two, creates a remedy, a very clear remedy for customers if the supplier does not act properly. Moving down, we then have unauthorized enrollment of service. So this basically says that if the supplier is not approved to be offering this, it's effectively slamming. However, there was a flag on this section, and I do believe that this section is referencing wrong. I think the intention is to reference the form submission section where the commission approves the offers. So confirming with the commissioners that your intention here is to reference where the commission makes those approvals, and then I'll make that conforming change.
Thank you, Ms. Knoll. that was the commission's intention as far as this commissioner understood. So is there a corresponding correct Comar?
Yeah, it would be
Site.
20.51 point, oops, sorry. 0.0310. Sorry, it's 0.0210. That's like,
Okay.
I made that note, so I can move one note off of our to-do list. Moving along into the consumer protection sections, this is where we left off. And I made a bunch of language changes here based on the discussion. The commission had not made final decisions on this section, but based on the discussion on the bench, I had made some kind of proposed compromises. But we can pick up here when the commissioners are ready, if we want to circle back to the other issues that were raised.
Thank you. Thank you. This is where we left off Thursday afternoon?
Yes.
Is that right? Okay. All right, before we move forward, let's tackle some of the first issues. We'll begin with the Office of People's Counsel.
Thank you, Mr. Chairman, Commissioners. Jacob Auslander on behalf of the Maryland Office of People's Counsel. We did send some proposed edits to this section to address the problem that I flagged on Thursday, whereby the statute protects a broader class of customers than the wording that the Commission has settled on actually reflects. So to recap, the statute protects households that have received energy assistance through an OHEP-administered program in the current or previous fiscal year under the Commission's interpretation. But this implementation seems to silo off the protections and would only, by the actual words in Comar, protect a customer receiving electric energy assistance from a contract with an electricity supplier. We reached out to Director Molyneux over the past few days, and she informed us that the definition that OHEP uses for the MEEP program references residential energy utility bills, and so that's a proposal from OPC now to include that type of language here instead of saying electric assistance program in 14 for energy assistance household and electric utility bills in 13 energy assistance program, to have it instead say residential energy utility bills and then residential energy assistance programs in household. And then that way we wouldn't have a situation where somebody was receiving energy assistance for, say, bulk fuel and then then get solicited by an electricity supplier and not be, by Comar, not be protected.
Mr. Auslander, didn't we tread this ground on Thursday?
We
where
did.
we recognized there was a bit of a donut hole and we couldn't protect.
That's correct. And so we reached out to OHEP to see how they had defined households, and we believe that the way that they've defined households for the MEEP program would be the most appropriate way to implement these regulations here, because the statute references OHEP's energy assistance programs, and the way that OHEP defines households for the MEEP program, they use residential energy utility bills. So we did cover this on Thursday, but my sense was that the Commission was choosing to limit it to electricity because of perhaps an inability to understand how you would capture what the statute is attempting to capture.
I guess I still have that concern with capturing, notwithstanding the definition used by OHEP, because in our exchange you said, well, if we make this a little fuzzier or vaguer, it could capture more. But doesn't this result in harder implementation for both the suppliers and the utilities?
I don't believe so, because the definition here is not going to affect what the utility is going to be required to do in the subsequent sections. This really, I think, would affect a customer identifying what protections they were entitled to under Comar. Because presumably the suppliers will know that the statute protects a broader class of customers than might be reflected in Comar if the wording that the commission tentatively accepted on Friday was finally adopted today.
Wasn't the issue that the utilities wouldn't know if someone was receiving fuel assistance, and how would they know?
That's correct, but this definition would not require the utility to identify that. As I mentioned, there's, I think,
How would a supplier know?
a supplier might not know, but as I mentioned,
That's the crux of the problem, though. How does anybody know who these people are getting fuel fund?
I think that there is a difficulty in implementing that aspect of the statute to come up with a screening process that would, catch 100% of the eligible customers. But there are some operative protections within the statute that could be asserted by a customer that was affected, regardless of whether or not the utility or supplier properly identified them at the outset.
I'm generally supportive of making consumer protections as broad as possible, but I can't give a responsibility to a supplier or a utility that they can't possibly meet. And they may be in violation of and subject to sanction. I can't do that.
Well, my reading of this, the statute is the operative body of law that is creating the obligation. So the regulation is an attempt to implement what the General Assembly has already said is the law.
Well, regulation is law.
That's correct. But to the extent that the statute protects a broader class of customers, I think that it is important that the regulations map to that.
I know, but we're executive branch, and we need to make sure we can execute. If you're suggesting something we can't execute.
I don't know that I agree. I think that the situations where I'm envisioning this, the change that we're suggesting coming into play would be a customer that finds out about the protections that they're afforded under statute and then contacts the supplier and says, hey, I was protected. You should not charge me a termination fee, for example, and you should be required to re-rate me for the 2 months that you were charging me above SOS because I've received energy assistance for my bulk fuel needs in the previous
But the
fiscal year.
reality is, if they offer, they violated COMAR. If the supplier offers, and this person's in that category, they violated COMAR per your suggestion.
Well, I think that one of the provisions that we are going to be discussing today is going to be what obligations the supplier has to inquire and verify the energy assistance household status. So depending on where we come out there, I think that's where we would define. And as I mentioned on Thursday, there was a desire by a supplier that wants to make sure that they understand what their obligations will be under this law. So I do think that your question, Commissioner O'Donnell, is very important, and it's one that at least one supplier has relayed to OPC and the stakeholders during the implementation discussions prior to these hearings. But I don't know that that the change that we're suggesting here would necessarily affect that. I think it would instead be a faithful implementation of the requirements that the statute already imposes.
Mr. Oslander, for the first time during this rulemaking session, I just heard you state that now the customer has responsibilities to go forward. And we haven't talked about putting burdens on customers, but you just stated that now it would be on the customer's responsibility to inform their supplier about potential energy assistance that they're receiving elsewhere. Is that right?
Yeah, I don't know if I would use the term responsibility, but they should have the ability to enforce the rights that the law has provided to them. And what I would be concerned about is them in their attempt to do that, in their attempt to flag to for example, an electricity supplier that they were entitled to the protections that the electricity supplier or CAD, for example, might look at COMAR only and not the statute and see that, well, this was not electric assistance that you received because bulk fuel assistance is not electric assistance, so you're not an energy assistance household as defined in COMAR.
Now we have the customer having to proactively contact the supplier to tell them what their rights are under the law. I don't like the sound of this. Director Molyneux.
Good morning, Commissioners. So I think it's also worth pointing out, and I think we discussed this a little bit last week, the supplier can, in fact, utilize my OHEP status, and it layers it out by program. So they have access to the information. If somebody is a MEP recipient, they can avail themselves to that information during a conversation with the customer. I don't think this is any different than your standard EUSP MEP recipient.
Director Molyneux, are they supposed to do that for every person they encounter before they offer them a product?
I think if they ask them, did you receive energy assistance, and they say, I'm not sure, okay, well, let's look it up.
Well, again, the burden is on the customer, but okay. If you think retail suppliers in this state are going to check every single customer their people are encountering to offer them retail supply,
I think after a conversation, it's reasonable.
well, maybe that's OHEP's opinion, it's not mine.
Although Director Molyneux, the customer would have to provide what, birthday?
And last four of their social.
Mr. Baker, any thoughts?
We could, just operationally, if we do go this way, we will need to change. There's a gateway COMAR that we put together where the utility is supposed to stop an enrollment if the customer, one, meets the definition of an energy assistance household, which is the reason that we went with only electric and gas bills last time. So we would need to put a qualifier in there such that only they would block those that they're aware of. So something along the lines of, only if you know will you make the block. And then second, we could go this way.
I'm not sure the advocates of the change in the law would be fans of that.
Right, I mean, that's one. I mean,
But
the
the
other
big
one is we would
loophole
have,
is-
so I guess if we walk through your options, that is the easiest for the utility, and that's following what we had gone with last week, but that's now putting more burden on the suppliers to do the discussion that you and the director of OHEP just had in terms of our in terms of how the suppliers are going to check ahead of time. So the risk is now back on the supplier in terms of checking ahead of time. I guess if we were trying to do comprehensive, we would then have to create the complicated. I don't know if it's complicated, but we'd have to create systems to share with the utilities every customer status in Maryland, and then their systems would have to be able to pick that up, which is I think the complication that we were trying to avoid with this change last week. Staff was in favor of these broader terms last week, but I think our issue was we admitted that was an operational headache that we weren't sure how we were going to resolve. And so we could mess with the operations if we want to go this way, and staff is willing to work on that. But I think the issue, or we could write our regs, but I think our regs on this issue would have to be either we're going to accept that we're creating a more complicated process for the utilities on the front end, or we're going to put the donut hole in our gateway COMAR where the utility only has the obligation to block those customer enrollments that they're aware of.
Thank you. I think in an attempt to faithfully execute the law and in an attempt to limit the burden on the utilities here, again, I have a lot of sympathy for the utilities being squeezed here. We are attempting to contort ourselves into a pretzel in order to provide universal coverage to capture this very small percentage of customers that may be in the hole. Electric is covered by electric, gas is covered by gas, and the folks that may have other fuel assistance. We've done our best here with a law that is not a model of clarity by any means. And as I stated on Thursday, the implementation of this law is not as simple as the drafters envisioned. I don't support the changes of OPC, but that's just my thoughts. Do other commissioners wish to revisit this topic? Commissioner Bubar.
I'm leaning towards not supporting it also because it seems like it's just really complicated, but maybe I just want to make sure I understand it. So with this change, adding the residential energy utility bills, which is good to line up with OHEP's definition, Director Molyneux, did I understand that basically the information would be there in the My OHEP tool, but the burden is that it would have to be done person by person? I mean, I'm really trying to understand, with this language, what is the implementation path?
That is correct. Your understanding is correct. The issue is the only way around this, aside from it being on the utilities to essentially enforce that information is a list from OHEP, which there are certain human service articles that prevent us from sharing that. So this is what we have to work with right now.
Okay.
If I may, Your Honor, if we did this, we could make modifications throughout the utilities role, limiting the utilities obligations, as Mr. Baker said, to where the utility knows.
But
what
isn't
had
that
to be
isn't that a loophole so large it eviscerates the intent of the law?
So,
It's a loophole that just eviscerates the intention of the law.
except
We're trying
that's
to
where-
avoid that.
But that's where we are
Well,
by the
if
definition
we
we've already
went there,
created.
but that was one suggestion kind of on the fly, but it's a loophole so big, as the chairman says, it doesn't cause us to faithfully and diligently execute the law because we're creating a loophole for the utilities. That's so big you could drive a Mack truck through it.
I think OPC's concern is that instead of creating the loophole in the definition, we have the utilities do what they can, but our regulations allow the commission to
So
enforce
here's my
more
fear.
broadly.
Many more consumers could be harmed if we were to implement ones that they are aware loophole than will be harmed by this other forms of energy assistance program. I'm certain of that. I'm very certain of that.
That may be one outcome, yes.
So we're trying to balance a lot of interests here, extend consumer protections to the extent that we can, but not eviscerate the law and put a lot more people at risk to the same protections. And it's a tough interest to balance because the law, I don't think, envisioned this discussion when it was passed.
Commissioner Linton.
Thanks, Mr. Chairman. So I think Commissioner O'Donnell just hit on the main point of the issue here. The Maryland Energy Assistance Program is actually, even though it has that title, it's a federal program. So the funds that come from it were not designed just to go to regulated gas or utility services, but to whatever heating source the customer wanted to use. So I understand we call it Maryland Energy Assistance Program, but that's not the genesis of it. So, I mean, the real solution here, at least from my perspective, is just to encourage customers to sign up for the LIHEAP money, using it for an alternative fuel, to also sign up for EUSP. I mean, that's free money. It's available for them. They can do it all in the same time, and it helps them on their electric bill. So we're talking about a class of customer that's not taking EUSP money to help pay down their bill. And instead, they're using the LIHEAP money just to buy propane or oil or some other alternative fuel. So there's extra money there to help them. So I don't see why we would create a regulation that would encourage a customer not to take money they need to help them pay their bill. So I'm supportive of the current language.
All right, we will move on. The commission will maintain its position on Thursday on this issue. Mr. Green, you had an issue.
Yes, Your Honor. On 510210, which is new section in red. In A, where it says beginning July 1, 2023, electricity supplier may not serve a customer in energy assistance household. We would like, for consistency with the changes that have occurred through the rest of the document, that should start with for contracts entered into on or after July 1, 2023.
I think that's a conforming change. Is that right, Ms. Knoll?
Yes, we use the term signed.
Okay.
Thank you, Mr. Green. Anything else?
This is just an absolute housekeeping issue. Is the language that we? My apologies. There's language that was added in Ms. Knoll's that had to do with the notice to the customers, and I don't know what section it is. I apologize.
Take a moment to find the site.
Is it
Here it is.
transfers of service?
It's in 530402K2. And this is just conforming language. There's two references in B and C to low-income customers, and I think that should be energy assistance households.
Thank you.
and that's all I have.
Thank you. I believe Commissioner Richard had commentary on this section.
Yeah, thank you, Mr. Chairman. In this topic of what we do with newly enrolled OHEP customers, after really hearing the arguments of Ms. Peltier, and Ms. Wine, I'd like us to reconsider the language that was, I think we referred to it as the straw man. In this particular circumstance, if I heard your arguments correctly, this would probably be the stronger customer protection in that if the contract, the retail contract, is no longer legally compliant, it would just automatically return that customer to standard offer service. It does provide the opportunity, the original language, stop me if I'm wrong, Ms. Knoll, or the opportunity at this stage for the retail supplier to re-enroll with a compliant product. But yeah, again, after hearing the idea that this would then put upon the customer to make sure that they were protected, and then potentially our staff to have to figure out if when they reviewed all the compliance filings, I guess the reporting, whether something was not in alignment. I just find that I think this is probably more compliant with the intent of the law, and again, I think it does provide a stronger customer protection in this case. And I think for retail suppliers, Mr. Green, you definitely would like to hear your thought, but I think that would be a protection to the supplier who may miss the notification from the utility or just not act in time. They would keep them in compliance with the law as well. So, but would still afford the retail supplier the opportunity, should there at some point in the future be a product that was compliant, that retail supplier to offer that product. And obviously it would be a very attractive product if it in fact is compliant and cheaper than SOS. So anyway, I'll stop there. But Mr. Chairman, I did want to ask if we could reconsider that. And Ms. Knoll, did I get that correctly? Did I say that correctly?
The straw man?
The straw man as compared to what we did.
Yes, there was an implementation challenge in the straw man, but I'm going to briefly just work from the structure we have here. So what we could do is say, upon receipt of the notice, the supplier shall terminate the customer to SOS, period. And then we can say, the supplier may, and then if either of may resubmit an enrollment, and then we have an if clause if this was provided for in the original contract or they obtain the customer's consent.
And also I would
is
invite
the
Ms.
implementation challenge.
Peltier or Ms. Wine to let me know if I'm getting your argument, if I'm stating it correctly too.
Good morning, Commissioners. I thought a lot about this too. And your walking it through is accurate. I just foresee about, it could be as high as 25,000 to 30,000 messages going from utilities to suppliers. And then the suppliers have to act on all those. That right there just seems arduous. I understand it does takes responsibility off the utility. But what it does do is it means that people out in the field, people at OHEP, people advocates, we basically have to find a bill that has an OHEP feed on it, notice the supplier, notice that they're charging more, send it into CAD, and then it's what we were suggesting as a backstop is, maybe there's, and I think I came up with an idea using current things is reporting. Is if the utilities reported monthly. So right now utilities report suppliers' sales and supplier drops. And you get that on the monthly enrollment report. What if the utilities reported not only supplier drops that came in the current way, but supplier drops it would be reporting on the number of OHEP accounts that were hit. and then they could break it out on the report. So at least there would be data showing how many drops should go through each utility, and then you could compare how many drops were coming in. Because right now, that was a terrible way of explaining, trying to break out the reporting so that somebody in OPC or an advocate or the PSC could see how many drops should have occurred by the supplier and how many are actually dropping. I will say for the advocates, the intent was to have the utilities do the drop. So what I'm trying to lay out is this is going to happen for the next decade, the next 2 decades. We're all going to be gone, and as much that is automated should be automated. And if it's left to the consumers, I mean, there's just no way. I was even thinking about, do you do a letter to all the bulk fuel? It's all great when you have the passionate people who want to make it happen, and then 6 years later, when everyone's gone, it has to be as automated as possible. So that was just an idea I came up with for reporting. Is just to break out, is to be able to at least vet it. So even in the first year, you could see our suppliers doing it, because the way it's written right now, it's contingent on the supplier. So I hope that helped, and thank you.
Thank you, Commissioner Richard. You did characterize correctly our concerns, the concern I raised last week. The staff straw man proposal, I think, would better operationalize 4-308B32, because under the law, the third-party retail supplier's offer, if the third-party retail supplier offer is not approved by the commission, the third-party retail supplier may not charge a customer receiving energy assistance from an energy program administered by OHEP. I mean, the firm backstop drop better effectuates and makes sure that that money, those customers are not being charged inappropriately because the contract has not been approved by the commission. The risk we run with the OHEP model that was discussed, that was on the screen, the second K, is that there will be this lag period, that there will be customers due to processes and making sure that the emails going back and forth between the utility and the supplier acting, and then somebody catching something, customers that have fallen through the cracks. There is a risk there that 4-308B32, won't be complied with as well as it could be.
Okay, great, thank you. So I guess with that, Mr. Chairman, I believe that the straw man, and Ms. Knoll, again, tell me if I'm correct or not, is probably the cleanest and most direct way to, I think, to effectuate this.
Make sure we're all level set here.
Sure, so
What's straw man?
let me just explain what I've done on the screen.
Okay.
Because what I have on the screen, I think, is probably as close to what is workable. So the straw man originally had an implementation problem. So what I have on the screen, I hope, and I would trust the many, many attorneys in the room to backstop me on this one. So Commissioner Richard, your intent is for once the utility knows about a new OHEP status, the utility drops the customer to SOS. So that's what I've done in section 1. They'll notify the supplier within 3 days and return the customer to SOS. So then I've removed any obligation for the supplier to drop the customer because the utility has now done it automatically. What the supplier can then do is, upon receipt of the notice, if the original contract allowed for an automatic, without additional consent, switch over to an energy assistance household, the supplier can resubmit that. If that's not allowed in the original contract, the supplier can reach out to the customer, do a new sale, and then submit pursuant to that. And I think that at that point, staff's 3 may be unnecessary because there should be no gap on the prior contract.
So hang on. So thanks for explaining that for my question. So why would we have a commission-approved low-income offering of a supplier if they're going to get dropped automatically? 1. 2, isn't the utility kind of eradicating the contract between a third-party supplier and their customer?
Correct.
And what gives the utility the authority to break a contract? Now you're getting into contract law.
I think it's this regulation that.
Well, I
authority.
think that's a dangerous, dangerous precedent,
So-
that we authorize our utilities to break third-party contracts that we don't regulate.
Your Honor is correct. There's no mechanism in what I have on the screen for the utility to check whether or not the supplier potentially has a compliant contract. Because in our discussions with the utilities last week, the utilities made clear that they don't have any ability to receive information related to whether or not the customer's been transitioned to a compliant contract. So yes, this would result in the utilities breaking existing contracts and the supplier having to either resubmit or re-enroll, and the customer will see that on their bill. They'll see the original contract with the supplier, at least 1 to 3 days on SOS, and then the new contract price.
Mr. Chairman, I think we've sufficiently plowed this ground last week, and we're replowing it again, and I can't support this change for reasons I previously stated.
I see some deja vu with respect to our conversation last week. Ms. Knoll, or any of the attorneys, does the utility have any privity of contract between the contract that's signed by the customer and the supplier? Mr. Trout?
I agree with Ms. Knoll. I was standing to eventually address a related issue. But I agree with Ms. Knoll. There is no privity of contract, and Commissioner O'Donnell is exactly right that this is a disturbing proposed intervention by the utility into the relationship between the customer and their retail supplier. We'll do it if you order us to do it, but
Would that be a lawful order of this commission?
it'd be a lawful order. I believe you have the ability to order us to do this, yes.
Well, let me suggest this, that I think if a supplier took us to court on this, if we were to make this, we'd probably lose.
I apologize. I was looking at it from the utilities perspective. I think if you ordered us to do it, we would be insulated from liability. Whether your regulation would then be struck down, I was not professing an opinion as to that.
I suggest it would be summarily struck down.
I don't know if this is the right time, but I just want to look at the issue of holes, speak to that for a minute, because there isn't one donut hole. There are at least 3 holes in this. I have to say, going back to first principles, the only way to make this work as close as reasonably possible to what the legislature wrote in the law is for the suppliers to get low-income status information from the party that determines low-income status information, which is OHEP, and then the supplier has to then affirmatively refrain from making offers to those people. Any other way of doing this is going to be incomplete, overly complicated, and produce mistakes and omissions, and here overreach, interference with contracts. So you've got the situation we've been talking about, which is the utility won't know someone is getting assistance if it's a different form of assistance from the kind that is administered by that particular utility. The utility won't know if the customer received that same sort of energy assistance in a prior year, in the previous year, because it's 2 fiscal years under these regulations, if that customer has moved from another utility service territory. So even if it's electric to electric, if the customer moved from one service territory to another, there's the second hole. And then the third hole is these regulations are set up to a simple binary choice. Either the supplier has an approved contract with the commission, or it doesn't. So we don't reject them if there's an approved contract, even if the contract in question is not in fact the approved contract. 3 holes. It's starting to look. It's not a donut. It's Swiss cheese, and I know nobody wants to have the communications direct. I know everybody wants to try to leverage existing utility systems and existing utility communications with the suppliers, but very respectfully and very briefly, it won't work.
Thank you,
It's
Mr.
not what was done in Pennsylvania. And by the way, what was done in Pennsylvania, that didn't work either. And now there are no offers, or at least going forward, there are no offers from retail suppliers to low-income customers, full stop.
Thank you. I think you and Ms. Peltier agree that whatever's in Pennsylvania doesn't work. Commissioner Richard.
Yeah, just if I can, maybe a question or two more for Ms. Knoll. Okay, so, and I did hear Ms. Peltier, sorry, I keep doing that, Peltier. Yeah. Thank you. That, you know, it could be just in the reporting, and in reporting, then our staff would be responsible, or the customer would be responsible, I guess, for ensuring that that customer protection is in place. Is that correct with the reporting?
Yes, Your Honor.
Okay.
So
And
OPC has proposed some reporting requirements that we will get to later today, and
Okay.
there are things we could explore to have more information.
so
on
that
this
could be
front.
workable.
It could be, yes.
But I still want to explore practically the way the language currently is written. At the end of it, if there is not a compliant contract after July 1st, that customer must be returned to SOS. Is that correct?
The supplier has an obligation to terminate their service to that customer.
So the end result is the same, that because it's not compliant, that customer will be returned. What the language we're talking about now, I'll call it the straw man, but however you updated it, it just gets us there a little faster and more directly, because it is in fact, as of July 1st, not a compliant contract, and that customer has a right under this law to be returned to SOS unless the retail supplier has something to offer that is compliant. Is that correct?
I don't want to quibble with characterizations.
Okay.
But the law prevents the transfer of OHEP dollars to suppliers in those instances. And so having the utility directly remove them is the most direct way of accomplishing that goal. But I think there are concerns, as the other commissioners have raised, about having the utility play that particular role, if that makes sense.
Okay, but just again, if I'm getting this wrong, let me know. But in the draft we have before us now, not this, going back to the
What's on the screen?
on the screen, I'm not sure what I see all these cross-outs. The end result still is that customer has a right to be returned to SOS. And if the supplier does not return them to SOS, they will be not in compliance with the law.
Correct.
Okay.
Unless there's a commission-approved low-income product. And then you're going to force them to go back to SOS and then come back to the commission-approved product, which makes no sense to me.
But there still is a right, is that correct, for that customer to either go to SOS or return to or go to this new product, a product that does not exist?
So every customer in Maryland always has the right to return to standard offer service. That's the definition of a default rate. That rate is available to every customer. So regardless of their energy income status, they can always go back to SOS. In the instance, in either option that's on the table, either a utility automatic drop or putting the supplier in the driver's seat, if there is no energy assistance offer, the customer should return to SOS. The question is simply who effectuates that action, either the utility or the supplier. But the end result for the customer should be the same in both instances. And I think it's simply a question of who you think is going to be more effective at accomplishing that goal. But I think Commissioner O'Donnell does raise a very good point, which is that if there is consent in a contract for an automatic transition to an energy assistance approved offer, you have then put the utility in the position of breaking a legal contract, and the supplier then has to resubmit.
Okay, well, I do hear you. It just, at this point, it's just theoretical whether or not there are going to be these contracts or these products, but we do know that the legislature intended for this protection to go into place July 1st. And at this stage, it seems like this is the most practical way to get us there quickly without putting the burden on the customer or on our staff. So, and at this point, if there is a product such as supplier consolidated billing that, down the road is available, we can certainly come back and maybe improve the process. But again, I hear Ms. Wine and Ms. Peltier that this, I think, is the intent to provide the protection to these customers, and this does so in pretty much an absolute way. So anyway, Mr. Chairman, I'll end there and we can take the votes.
Thank you, Commissioner. This conversation, while somewhat duplicative of our conversation on Thursday, has only now reinforced my belief that we cannot have the utility intervening in a private contract between these two customers. I continue to support Office of People's Counsel, their position. I think it's a much simpler way to implement. Ms. Peltier, we're
Okay.
taking a vote, but I'll...
Okay, I had an idea. What if the supplier contracts, which are very lengthy, I've read a lot of them, had a clause in there that said, if a customer does get onto OHEP, then it would not be a contractual break. And you put it in the supplier's contract that it wouldn't hold the utility or the state or anybody at, so it said that if the customer changes, then it would be written in that contract, and then that contract would effectively say it's okay for the contract to end by the utility. It's just an idea, because this is it. So I
But
thought,
I don't know that we've dictated terms and conditions of private contracts between
Well-
private parties. I don't know that we've ever done that.
but the contracts have lots of clauses of what have to be included in them.
The law does, but now we're going to create through regulation a term or condition of the contract, in the contract. I think this is, with all due respect, and I appreciate your zeal and trying to do the Lord's work, but it's kind of a dangerous way to do rulemaking, is to kind of zing ideas on the fly, because you don't think about things maybe the way you should. So, I'm sorry.
Other thoughts on Commissioner Richards' proposal?
Did Mr. Green have something to say?
I think my position has been stated, but just to reiterate, we support the language that was on the board initially, which I think was OPC language, that suppliers will get the notice from the utilities and the suppliers will act. And if they don't, then, there'll be a problem with that compliance-wise. And there may or may not be contracts in the market that are approved for energy assistance households in the event that someone goes from non-energy assistance to energy assistance. But I agree with Commissioner O'Donnell that it doesn't make sense to me to have a customer automatically dropped by the utility when they have a contract that says they would get the energy assistance protections if they were energy assistance households. You shouldn't take that away from the supplier when that is a arm's length negotiation with the customer that the customer agreed to. And the customer, we're talking about customer protections, the customer agreed to that type of contract, and then you're taking it away from them by having the utility breach it. And then the supplier has to go through the process of re-enrolling the customer. As far as, and to the extent that's going to happen, where suppliers can transition a customer over to an energy assistance household contract, you're going to have reporting mechanisms at the end of the year. So that will be traceable. So for those reasons, I would ask that we stick with the language that was up there at the beginning of the day.
Commissioner Linton?
Thank you, Mr. Chairman. So, a question for Mr. Green. There has been some suggestion that there will be a challenge for the consumer prior to the period that the commission does its audit or review or gets the reports and finds that the supplier didn't switch the customer when they were supposed to. Since you represent some of the suppliers, what is your response to that? I mean, there could potentially be one of your clients, or perhaps somebody else's, but I'll say somebody else's, since you wouldn't advise them to do that.
But someone who becomes my client who is not yet my client. How's
Yes,
that look
exactly,
back?
exactly. So what would how do we address that part of this issue?
Well, there's a couple ways. One is when you do see those reports, if there's a problem, then that supplier or suppliers or all the stakeholders need to know about it. Second is that there could be more frequent reporting requirements in the first year or two of the program, and then extend it out on an annual basis, maybe have 6-month reporting or quarterly or whatever you might decide on, and then have more lengthy durations in between the reporting periods, so that you can see the immediate impacts of the program more often. And those are two things that immediately come to my mind.
So the reporting is an interesting way of dealing with it. At least gives us a heads up a bit faster, which I think is, I can appreciate the concern. I mean, it is a cat and mouse at some point, where the suppliers we let them know, and then we just wait for customers to let us know there's a problem. And while this commission has been far more active historically than other commissions in pursuing suppliers that are in violation of our regulations, that does create a bit of a challenge for our Consumer Affairs Division and even for the Commission to try and catch them when we eventually catch them, and just what the harm will be along the way. So I don't think we've spoken a lot about the reporting requirements portion yet, so.
We have not gotten there yet.
Okay. All right. So maybe that's the right place to address this concern, given some of the other operational challenges that we have. But I do agree that it's an issue that we need to take a look at. Because the last thing we want to have is customers who have this challenge for extended periods of time, facing service denial and all the other issues that come with it. And then we finally catch it, go after the supplier, and then that's a protracted period of time. But the customers are kind of caught in the middle. But I think there's a way, I agree with Mr. Green, there's probably a way to deal with this under the reporting side.
Without majority support for Commissioner Richards' proposal, we will revert all of the changes to how they were about a half hour ago.
Maybe 1 second to do that, and then we can move on to the next section. You know what? I think it's faster to do it this way.
You can highlight them.
Please hold on.
First time for everything.
Mr. Green, I just removed your energy assistance versus low income, but I'll make a note to go back.
Fair enough.
Ms. Knoll, are we back to where we left off on Thursday?
We are.
Okay.
So in this section, the way that it was originally worded was it prohibited suppliers from marketing offers, and it created an obligation on the supplier to make reasonable efforts to determine whether a customer, is an energy assistance household. There were edits suggesting the inclusion of general marketing materials, and also edits suggesting that all door-to-door sales must be recorded. So after the discussion, which is now alternative 3 that's on the board in yellow, I modified, there was concern that marketing was too far afield from the statute. It was kind of capturing more than intended. So now it's no longer marketing. It's that a supplier may not make an offer to an energy assistance household unless the offer is associated with a commission-approved contract for energy assistance households. A supplier must make reasonable efforts to determine whether a customer lives in an energy assistance household, and I've modified that from during the solicitation to before submitting an enrollment. That gives the supplier actually the opportunity to use the pre-enrollment information that we identified earlier. General marketing materials, I made a conforming language change there. And then finally, there was concern about customer consent to being recorded and the customer experience of having a stranger walk up at their door and say, hey, by the way, you're on camera, or on a cell phone recording. And so now it says that a supplier, and the concern that staff was raising was about a he said, she said situation about whether or not the supplier knew that a customer was on energy assistance. So I've created a obligation for the supplier to attain a written confirmation of energy assistance household status before enrolling all customers. So I attempted, based on the discussion, to produce some compromises here, but obviously all of this is open to additional edit and discussion.
Can I ask you a question?
Certainly.
Am I wrong in seeing 3 and 3A as being contradictory, as it's written here? A supplier may not make an offer to an energy assistance household unless the offer is associated with a commission-approved contract for energy assistance households. So, but the A says a supplier must make reasonable efforts to determine whether a customer lives in an. So if you make reasonable efforts, doesn't that contradict 3, which says you may not make an offer?
So
It looks like contradictory language.
I will let staff speak to this, of course. I don't think you're wrong, and I think it could use some tweaking. But, offer is a legal term. If I recall correctly, it's the manifestation of willingness to deal such that the other person understands that acceptance is invited and will conclude the deal. So when an offer occurs is a very nebulous question in a contracting interaction. So we could certainly modify. I simply selected offer because of what was in the statute. So if the commission wants to modify based on timing, we certainly could. But I was simply trying to create a situation where the supplier would not have to ask that question immediately, but could ask that question once they were closer to concluding the deal, if that makes sense.
Commissioner, I do agree. I see the contradictory there. I was going to say we could reword it to say this might be a loophole concern for yours. So, but the language could be a supplier may not knowingly make an offer. That is a significant loophole.
Yeah.
But at that point, that does get past the concern of an absolute in the first part, and then a reasonable efforts that in the second half.
So the law doesn't say knowingly. The law says can't make an offer.
Right.
And the law is the law. Do we need 3 here? Do we need to restate the law?
I think I had heard from some of the parties that there was trepidation amongst the suppliers about how they could make any offers in the market and still be compliant. And that some regulation clarifying what their obligations were would help them train their folks more effectively and approach the market more securely. Because if it is simply you may not make an offer, period, then they simply cannot market without knowing a lot more about when is it an offer, when is it marketing, what's a solicitation versus an actual, concluded contract. And it just creates a lot of risk for them in interacting with the Maryland market overall.
Mr. Green, you asked for 3 and 3A to be struck. Are you more comfortable with 3 at this point, with the knowingly language included?
I'm more comfortable with it. I think our proposal today is that we strike it, even with the knowingly language. Our proposal is that to the extent that there's going to be, number 4 here, the supplier must require written confirmation, that be a contract term that we'll take up in the next couple pages, so that they get that written confirmation or affirmation, if you will, from the customer that they are not on an energy assistance program at the time of signing the contract. As far as there's a lot that I'm concerned about with this alternative 3. Knowingly does make it a little more palatable. However, I don't know why we have 3 and 3A, and B raises concerns because I don't know what a general marketing material is as opposed to specific or something else. And I don't know what the
Let's
process would be, but-
take one at a time. 3. Your concerns with 3 are?
I don't think we need it, because if we have something in the contract where the customer affirms that they're not an energy assistance household, then that's,
Well, what if there's no contract? What if you just knock on somebody's door and you get nailed for knocking on a door when you knew that everybody on this block receives energy assistance?
how do we know that? I mean, we don't, that's the whole problem, right? That's the dilemma that we're in, the suppliers are in, because we don't know who these people are, and,
Well, but then this protects you. 3 protects you because you could say, I didn't know.
Yeah, but that creates problems for me, Mr. Chairman, because it's a loophole you can drive a Mack truck through again. We just deny knowledge and go offer to everybody. That's less consumer
then
protection.
you're gonna get into issues at the commission, I'm sure, about what did you know, when did you know it, constructive knowledge, actual knowledge. You're gonna have all of these contested issues going forward. Again, like I said, it's a little more palatable than not having the word knowingly in there, but it's still very troubling.
We have representative from SFE Energy and then Mr. Trout.
Good morning. Just following on to that, I think we talked at length last time about the fact that suppliers don't know the status of the customer at the point of the initiation of the sale. And upon further reflection, we're concerned that even asking the question to the customer could potentially be construed as discriminatory. If we weren't in the context of this case and we talked about a supplier asking a customer, are you receiving assistance payments? I think that could potentially be construed in an alarmingly, as being an alarmingly discriminatory thing to ask. So if that were to be the case, we think it's probably more appropriate to focus a verification step post-sale, like Risa was suggesting, something, the written confirmation or something along those lines that happens after the sale has taken place.
May I just ask one question on that, ma'am? Oh, I'm sorry. So, can you envision a marketing pitch where you state, we have a very attractive offer today, and you could say a little bit about it, and it's available, well, or you can just state, Maryland law says we cannot offer this if you receive energy assistance. So you just put that disclaimer in. Is that something that, I mean, would still allow your company to I guess, solicit business, but also, again, be able to, as it states here, if we were to go with number 4, be able to inform the customer about the limitations per Maryland law?
I guess I thought that the way that this was unfolding was that it's going to require us to ask the customer directly about the status in order to comply with 3 or...
Well, I'm just trying to understand the resistance to, again, a solicitation pitch that just does not, that would inform a customer of the law, the potential customer of the law, and then, just say, okay, I cannot sell you this product if you receive assistance. I'm just trying to figure out from what we have before us now, why that would be a limitation to a retail supplier. And why you think that somehow that would be discriminatory to just state the law.
Obviously, so yes, stating the law would not be discriminatory, but then the exchange, once you get past the initial, this is what the offer is a question. It's asking them their status. So that's sort of the nub of the issue here is we don't know that entering into the sale. And if we focused the verification post-sale, then I think we avoid any appearance of it being a discriminatory factor.
Okay, well, I understand your answer. This seems to be workable to me, but I'm just trying to understand, again, why in all circumstances a retail supplier could not work their marketing
solicitation around these requirements. So, thank you.
Mr. Trout.
I'll begin by noting I had absolutely no hand in drafting or editing any of this language in 3 or 4, and that most of it relates to the activities of the suppliers that I do not believe it's necessary or appropriate for me to take a position on. But I'd like to focus your attention on 3A and particularly 3A as it's been revised here with the language that says before submitting the offer, before submitting the enrollment. Not to put too fine a point on it, 3A is exactly what I have been asking for at the prior hearing and this morning, which is that the supplier has an obligation before they submit an enrollment to try to avoid doing something that would be a violation of the law. It would still, if you adopted the other parts of the regulations, you would still have the utilities doing things that I don't think are going to accomplish the objectives that you set out for the utilities, but it becomes much less important because the utility is transformed by 3A from the gatekeeper to being a backstop. That may solve a lot of problems, including the problem that I raised at the beginning of the last hearing, which is that this whole scheme of having suppliers just submit enrollments, whether they're for low-income customers or not, and then the utilities being the ones who determine compliance with the law by rejecting the enrollments, is in itself a violation of the statute. If that determination is made through whatever means the suppliers choose to adopt, of their fulfilling their obligations under this 3A, and we're just a backstop, a check on them, an argument could be made that you are complying with this statute and you've just created a backstop, as it were.
Ms. Wine?
Thank you. Just in response to whether or not the inquiry as to energy assistance status is discriminatory, from our organization's perspective, it is not. It is necessary for, at some point in this transaction, compliance with this law, because the law 4-308B1 is focused on the third-party retail supplier may not offer to, and then it sets forth the commissions. The offer is sort of the framing, the time of the point in time, and a verification post-sale appears to me to be in contradiction with the law's intent with that language.
Ms. Wine, you heard from Mr. Fitzgerald and Mr. Auslander their concerns with just sharing all of this information with the suppliers, which solves one problem but creates another.
We are of the same position of protecting the privacy of the energy assistance recipients. Therefore, we're more comfortable with the individual inquiry versus the release of lists.
What's the difference, though? One versus many?
Consent. The individual has the agency to exercise consent for the sharing, and you know it. And it is more controlled than a wide distribution of lists.
Ms. Wine, so the statute that appoints this commission says that the commission should reflect the gender, racial, geographic diversity of the state. There are probably other quantities that are listed there. And I come from a rural part of the state, so I represent, I think, arguably the only rural representative on this commission. And still in my community, or the community that I represented in the legislature, 2 different counties in rural Maryland for a couple decades, people are proud. They don't necessarily want to disclose. They don't want to say, yes, I'm on assistance. There's still some stigma associated with that. What do you say to that? Because you're putting the burden on them to disclose private information. It's like you have to disclose to me your health status in violation of HIPAA if you want my service.
I understand, and thank you, Commissioner. And we understand that as well. This is a more sort of voluntary. We're talking about a sales pitch, so it is not something. As Commissioner Richard sort of modeled, there are ways to frame the reason why you're asking the question. And if the reason why the burden is on the supplier, but I submit that this is a consumer protection law that these rules are intended to effectuate, and
I understand that.
it's-
I know that there are some people who are too proud to say, yes, I'm accepting assistance.
understood. And customer acquisition is a skill, and there are people that specialize in customer acquisition, and it will fall upon them to find a way to approach.
So if that person who finds some stigma associated with that kind of fudges the facts a little bit to the supplier when asked that question, does the burden go to the supplier if they enroll them?
Well, it depends on, I guess, perhaps if we keep the word knowingly.
Yeah, but don't you understand that putting the word knowingly in there puts the people you're trying to protect at much greater risk than without it there? With some suppliers in the state, I'm shocked you're actually arguing that.
Well, I think.
Not Mr. Green's customers, of course, clients.
Well, this is exactly the reason why I was arguing for the firmer, like, automatic drops
I
and
know.
easier ways to implement the law. And now if we're in the world of, we are almost in a caveat emptor world here, right? I mean,
Well,
so,
kind of, but we can't create bigger problems by solving smaller problems. And then you seem to be suggesting that.
well, no, I'm not, there is a solution. I mean, just because it may add time to the sales transaction and it may require the customer acquisition specialists to be more creative.
So you're advocating for the word knowingly to be in there.
Well,
Is that right? Am I understanding you correctly?
are we keeping all the other sections in there?
Wow, I don't know what we're doing.
If there is a concern about conflict with 3A, so it's a conditional.
You raise a good point, Ms. Wine, and I don't want to be going in circles, or we'll be at the lunch hour soon enough. So we've heard a number of arguments. I'm going to tell you what I think, and then the commissioners could share their views and see if we get to 3 on any of these. I'm really sympathetic to Commissioner O'Donnell's concern with the knowingly in 3. I'm going to support 3, but I recognize that this could be used as a shield and a sword by some unscrupulous suppliers. That said, this entire rulemaking is messy, and there will be some loopholes. I support 3. I do not support 3A. I don't know what a reasonable effort is. I do not support 3B. I do not know what general marketing materials state. And I agree with the commentary on 4, that this is better addressed in a different section. So I only support 3 with the, knowingly support 3 with the words knowingly in it, recognizing that there could be trouble down the road.
You support knowingly being in there?
Yes.
Chairman, I would agree with your proposal. I support the word knowingly, knowing that it might not actually be consistent with the law, but I think it's better than without having it in there, and I don't support A or B because I think it's challenging to implement.
So, hang on. Oh, are we going down the line here, or what's?
No idea. Commissioner O'Donnell, Commissioner Richard, Commissioner Linton.
Look, I'm not supporting the word knowingly being in there because we have seen too many suppliers in this state who we'd have to sanction because they are bad actors, with all due respect, who took advantage of our citizens, who violated consumer protections. And I'm not going to chronicle them, but there have been some bad actors, and they've hurt retail supply, and they've hurt our citizens. And to give someone the word knowingly of that ilk, to me, is disastrous. And I will definitely not support the word knowingly being in there. And I don't, if the word knowingly comes out, I'll support 3, and I can take out A and B, that's fine. But if knowingly is in there, I don't support any of it. I think it eviscerates the protections we've spent many hours trying to craft here.
Commissioner Richard.
Yeah, I do support your proposal. I think that we can, if we put knowingly, we can eliminate A and B. And, I believe that this is a very workable way to give the retail suppliers an opportunity to market, but also hopefully be right up front about the whether the product is available, is compliant or not. And of course, a customer doesn't have to say any reason why they've decided not to take the product. I mean, it could be for numerous reasons. So I think 3 is, but I would at some point like to know where do you intend to put 4?
We'll get to 4 in. I feel like the colors are changing on my eyesight. Well, was it a different color a moment ago, Miss Knoll? Because
No, let me delete this comment, and then it'll be easier to read.
I was able to read it a moment ago. Okay.
It just seems like a reasonable check at some point, and I just was interested to know why, if not here, where.
Right. Oh, no, that was in the comment that just disappeared. Sorry, Miss Knoll, I was looking at the bubble comment.
Oh, you want the bubble comment?
Yes, because there's a proposal that
I can't read the.
housed
I,
in the
I can read it out loud.
Yeah, can you please?
Sure. This is likely to be better housed in the consent to contract provisions, but is put here to be considered as an alternative to staff's proposal to record solicitations. And, Your Honor, I recorded that you indicated that you would like to relocate this.
Yes.
So that's the current proposal for voting.
Okay, and I'm fine with, as long as it's somewhere, but where is it being relocated?
Further down.
There's there are, well, I didn't identify actual sections. We have different requirements for consent based on the marketing channel, so we'd have to check for including it in the appropriate locations, but we can find a spot.
That satisfies.
Commissioner Linton.
I keep reading this over and over again, and I don't like the word knowingly in there. I do think that could be a challenge long term. I can see a lot of issues coming out of that. I don't really like A and B for other reasons that haven't been discussed, but so I'm kind of glad they didn't get discussed. So I would support 3 without the word knowingly, and 4 is fine.
Noting the objections of Commissioner O'Donnell and Commissioner Linton with respect to 3, there is majority support. We can move on.
Thank you, Your Honor. So this next section is under disclosures. So these are disclosures that suppliers have to make. The original obligation was that an energy assistance household cannot be charged more than utility standard offer service as something that has to be disclosed with a price when it is quoted to the customer. RISA has suggested the addition of if applicable, and then there's additional suggestions related to being under a contract signed on or after July 1, 2023. And then the second term here is that a supplier's price there must be a statement that it's not regulated by the commission. And then 3 is that if a supplier is marketing an offer to energy assistance households, the following statement is required. An energy assistance household cannot be charged more than the utility standard offer service rate. This was a suggestion from RISA. So we can handle these together, and I believe we'll probably be close to lunchtime.
May I explain the comment? So if you look at 2, all we did, by the way, in what is now C, we would propose to just move that down to number 3. It's in the way that it's drafted originally, it's in the price section, So in marketing materials, if a price is quoted, then 3 statements are required. And that's that the price is for the specified commodity, doesn't include tax, distribution charges, and that the price is not regulated by the commission. So to put this particular provision, excuse me, to slide it into that price section it wasn't the right place for it. Excuse me. So what we did is we moved it down and said that if you're marketing, this type of contract, you've got to have a specific statement. An energy assistance household cannot be charged more than the utility standard offer service rate.
And if I may clarify, Your Honor, the if applicable, which I apologize, I attributed to Reese, I believe it's from SFE, just to verify, yeah. The if applicable, and then if marketing an offer for energy assistance, means that these statements would only need to be included on energy assistance household offers, not in all market contracts. The original straw man intended to include this statement on all contracts for 2 reasons. One, visibility, and second, so that the customer would know that if they ever went into OHEB status.
Yeah, that's correct, and we pointed that out in our comments, that that's another reason why we would move it out of that price section, because if you're making offers to what we hope are non-energy assistance customers, we didn't think that language was necessary if we're quoting a price.
I support the new 3, striking C. I think 3 has some capitalizations that need to be changed.
Mr. Chairman, maybe I would propose a modification to 3 to be more inclusive. They do need to identify the type of offer. So in terms of if you're marketing to non-low income with your price disclosure, it needs to state that your energy assistance households are not eligible. And then offers that are for energy assistance households, it states that you are eligible. And then it's inclusive of all prices. It's clear which contracts can go, or what price is eligible for who. So then we don't have, ambiguity in our price disclosures to customers as to who can take what. So, which was what C originally was accomplishing. So, because C was going to be on everything in terms of saying, but that if we just say if you're doing an energy assistance household, I guess it'd be price must clearly state that an energy assistance household may or may not enroll in this offer, depending on the type. I guess depending on the type language needs to be changed.
May or may not enroll.
I can clean up some of the phrasing. I'm wording and phrasing, I think, but I believe I've effectuated what staff is looking for, so that all supplier marketing or solicitation information must include one of 2 statements. If it's a commission-approved offer for energy assistance households, then an energy assistance household cannot be charged more than utility standard offer service rate. If it is not approved for energy assistance households, it needs a statement that an energy assistance household cannot enroll on that product, offer, contract. We can work on the actual words.
And are we deleting C?
You can delete C.
And C would be deleted in that
Yeah.
instance. So we've moved it, it's no longer associated with a price statement, and now it's associated with all marketing and solicitations.
Mr. Green?
one of our goals, frankly, is that if you have suppliers that just want to make offers to not participate in this program, and now you've got something else that's got to go on their marketing material. You know, if they send something out and they put a price in there, they now have those 3 statements plus this additional statement, and it's all going in the fine print.
Mr. Baker, why do we need B? Let's assume that the
I
overwhelming.
mean, this is getting to the. I think we were we were comfortable with C in the terms that it was just stating if your energy assistance household, this is the terms for you. But if RESA is looking to strike that, we're looking at it from a perspective of we need to make sure that the customer is clear what they can and can't enroll in. If we have a supplier out there making offers and they try to enroll with them, that supplier is not eligible to do energy assistance for that customer, and we aren't doing anything up front to check, which it sounds like we're not. I think we need to put stuff in our marketing material to make sure it's clear that you're not eligible for this offer. The customer, I guess, is having to do some discerning from the marketing material, but now the marketing material is at least telling the customer you're eligible or you're not eligible up front. So I mean, if Mr. Green's clients want to not have the discussion with the customers, I don't know. At what point is the customer going to figure out they can and can't get in on this product?
So I can already, not to really muddy this, but I can already think of situations where I have a client that puts that statement in a marketing material, signs up the customer who actually is an energy assistance household, and my argument is going to be that I did not knowingly sign that person up because it was in the marketing material that this is not eligible. So already there's the crosshairs of what we're trying to do. Again, you know, there's only so much information that can go into a marketing material other than what you're actually trying to market.
So you would, in a CAD proceeding, use the postcard as evidence stating that the customer knew, the low-income energy assistance customer was aware that they could not enroll in this product.
I absolutely would.
I think that's a fair point. And we'd likely have to find in your favor.
And now I will be ordering the transcript of this proceeding.
Excuse me, there are 5 votes up here, sir. No, not 1.
Understood.
And Mr. Baker, Mr. Albert, what we have the term all marketing or solicitation information. It could be a letter, it could be a phone call.
I think I was thinking of it just on the pricing material because this is the price section. But
Yeah, if we move it down to 3, we're no longer associated with a price quoted.
So we're not talking about the postcard, the mailer.
And keep in mind that I haven't reviewed this recently, so I may be wrong. But often when we say price term, we mean an actual number. If something is simply a fixed or variable rate, that's not necessarily considered a price term.
I mean, Mr. Chairman, staff is not strongly in one direction or another on this. I think you're going to have the same problem you just mentioned with Mr. Green in terms of an enforcement proceeding. If we keep the 4th, we went back up to the marketing section, that term 4, where the contract there needs to be something in there that the customer says, I know or not know that I'm signing. There's an energy assistance disclosure that we're contemplating putting into the contracting material. That also creates the same problem because the customer is effectively going to sign something saying I am or I am not an energy assistance household.
If we have the problem in one place, do we need the problem here as well?
So I would say, staff, I would just note that, if we've now adopted the word knowingly, we took out the phrase reasonable efforts. My concern is that, it's maybe death by 1,000 cuts. I mean, I'm just really concerned with getting away from a statute that has an absolute directive in there.
That's right.
It doesn't say reasonable. It doesn't even say reasonable efforts. It says thou shalt not. charge a energy assistance household unless it's a compliant offer. And, I'm maybe a little too late here, but my concern is, everything is each step sort of dilutes that directive, an absolute directive in the statute that says you can't do it. Now, we appreciate there's there's suppliers figuring out exactly who those customers are. We may need to work on that, but I think we're just sort of setting up a whole bunch of defenses here.
Can I ask you a question on that? Do we have the authority under the Public Utilities article to dilute the black letter of the law as passed by the legislature and signed into law by the governor? Do we have that authority?
Unless we can show that literally it's something that can't possibly be done. We say couldn't amend that, but I don't think we're there. I don't think we're close to
As a
being.
proud former member of the legislature, I don't think any administrative body in the state has the authority to do that.
Yeah.
And we've done that, and that's the point you're making.
Yeah. And again, my point is, I could imagine an extraordinary circumstance where you say, well, that's just absolutely impossible to do. We've talked a whole bunch of obstacles getting information from OHAP, but, and I appreciate that for the suppliers, getting that information will be difficult, but boy, this now takes away virtually any duty. Knowingly is a big loophole there. Nothing explicit about reasonable efforts. And again, as you say, Commissioner O'Donnell, the statute doesn't talk about reasonable efforts. It's an absolute prohibition. It's going to be difficult to administer. I get that. But I'm concerned that we've just set up a whole bunch of defenses here.
If I may, I know that on Thursday, one of the provisions that the commission, I guess, tentatively accepted was that included in the pre-enrollment information was going to be information about whether the customer was an energy assistance customer. Could that be a potential way of maybe addressing the commission's problem with this section, and maybe even going back to the knowingly to impose a requirement that before the supplier submits the enrollment that they gather that portion of the pre-enrollment information and confirm that at the time they're submitting the enrollment, the customer is not listed with the utility as being an energy assistance customer. And that might fix a lot of these problems about what they knew or what they didn't know and what was reasonable and what wasn't reasonable. It would just be, you have access to this information under the pre-enrollment sections of COMAR, and that you have an obligation to make that check before you submit the enrollment to the utility.
Your Honor, would you like me to scroll back up to that section? I think
Mr. Oslander, would you say that language would obviate the need for this language?
Well, I actually do support staff's thinking that we want to make sure that I think part of what we were what they were attempting to do here was to educate consumers about what their rights are.
Right. But then the consumers will have this in the fine print, and Mr. Green will use this as a shield, saying, "Hey, they knew. We gave them a copy that said they shouldn't be on this if they're energy assistants, and they were. So I get a get out of jail free card."
Well, I guess if we kept this and we also adopted a requirement that the supplier check via the pre-enrollment information what the customer status is, then that argument would probably be unavailing, because if they had performed the check, because then that would mean they either performed the check, found out that the customer was an energy assistance household, notwithstanding the statement in a postcard or anywhere else, and still submitted the enrollment, or they didn't they didn't seek out the pre-enrollment information as required if we do adopt a requirement that they do so.
Ms. Knoll, did you want to scroll up to that area?
Your Honor, I can just say if the commission is interested, we could create an obligation here. And this would be much stronger.
I will say, Ms. Knoll, I think the reasonable efforts is the problem, and that creates the same big loophole that staff's concerned about with knowingly. But there's multiple ways the supplier ahead of time can figure this out. Pre-enrollment information, the OHEP portal, or they can talk to the customer, right? So I wouldn't want to preclude them from using the other two options for the pre-enrollment, which we do know will take a couple days before that clears with with the utility after a conversation with the customer. That being stated, that is what you're putting here is a way to do it. I guess it's just the reason. I think the issues with reasonable efforts and knowingly, those do create those big loopholes that we're going to have to deal with in an enforcement proceeding, and staff acknowledges those as huge problems.
So we've given them three options of how they're going to acquire energy assistance household status. Customer inquiry, checking my OHEP status portal, or acquiring pre-enrollment information for customer enrollments to determine their energy household status. So we could create an obligation that the suppliers must check one of these three things before they submit an enrollment.
And we would have to do that for every single enrollment. There are thousands of enrollments across the state happening every day.
Correct.
So for customer inquiries, we've talked about how uncomfortable that is. Checking my OHEP status, we've talked about how not feasible that is, because and we'd have to ask the customer for information we don't otherwise ask for, such as the last 4 digits of the social. And acquiring the pre-enrollment information, which I believe was discussed last week, that numerous suppliers don't use, and it adds time to the enrollment. This would remarkably change the way enrollments and marketing is done in Maryland and make it way more difficult for suppliers to do business here.
Mr. Green, can you explain why do some of your members not use the pre-enrollment information that's made available?
Things I've heard are that it's time consuming, it's not instantaneous, so and then you have to get the consent to do that from the customer when they've already consented, they're ready to enroll. Excuse me. And I believe there are other, I'm not, excuse me, I'm sorry. I can't seem to cure this. And then my understanding is, and please correct me, anyone here if I'm wrong, is that there's an added transaction cost for these EDI transactions. And so you're talking about, think about all the enrollments you have, and now you have an extra transaction going back and forth from the utilities to the supplier to the utility and back of the pre-enrollment information. So it really does complicate things to make this a requirement for every enrollment, because that's what it would have to be.
The staff would point out, the law is clear. The law, Ms. Peltier actually filed documents on November 1, I think, showing us 3 customers are paying on average $366 a year more for service. I think she was referring to electricity suppliers as opposed to the utility service. This is a big problem. And the fix from the legislature was unconditional, as Commissioner O'Donnell points out. There's directives in here, nothing reasonable efforts, nothing that sort of suggested if you can, try your best. And yeah, it's gonna put, I appreciate, Mr. Green is earning his pay today. He's very eloquently pushing back on any sort of measures that would sort of give teeth to this and make it more of an obligation. I think specifying, frankly, from his perspective, specifying what those reasonable efforts are gives him protection, certainly will save us a lot of effort in enforcement procedures. I appreciate Commissioner O'Donnell's point about the customer inquiry. I think asking the customer their status should not be sufficient because of the stigma aspect of it. But by specifying what those reasonable efforts are, I get it. It's a burden on suppliers, and they don't want to do it, and I wouldn't want to if I was in their shoes. But we're dealing with a huge problem with the most vulnerable customers, and the legislature's made that call.
Mr. Green, isn't Chapter 637 of the law designed to make the life of your clients difficult?
I don't know what 637 is.
What we're discussing, the statute.
4308.
It was designed to protect customers from being priced higher than standard offer service and sales service. We have numerous suppliers in the market today who dedicate significant resources to compliance and try to do the right thing every day. And now, because of possibilities like this, they're going to see transaction costs grow up. They're going to see it make it harder for them and their vendors to work together and to sign up customers and to just go to bring new products and services to Maryland. It's going to be a hardship, And that's, I know we're focused on the bad actors. We've talked a lot about that today. But more so in the market today are the good actors. And those are the ones that I'm trying to watch out for today, that because they want to comply.
But that's my question. This new law affects the good actors and the bad actors and requires that the good actors ensure that they're not signing up OHEP customers. So if you have an objection to one of these three methods, are you not required under the law to use either one of these methods or another method to ensure that the customer is not receiving assistance?
Right. So what we would like to do is have something in the contract itself where the customer affirms that they are not an energy assistance customer and have not taken energy assistance in the last fiscal year, whatever the language is. And we ought to be able to rely on that. That's the customer's affirmation in the contract that they are not an energy assistance customer and haven't taken it. So,
And that's it. That's it. That's your position.
Correct.
And the customer that has pride and lies and signs the affidavit provides you with all you need to combat any type of investigation by CAD saying, hey, the customer told us that they're not on energy assistance. We had nothing else to go on. Would that be the position of a recent member?
Well, certainly if the supplier's testimony or whatever is that they asked the customer, are you on energy assistance? And they said no. Or we have an offer that specifically states it's not for energy assistance customers and they called us anyway and enrolled and signed up for it, then I think it's perfectly reasonable for the supplier to be able to say, yes, we made them an offer, but here's what they told us. We relied on what they told us. We rely on that every day, today.
And we didn't knowingly violate anything.
Right.
Because they told us that.
Right. I mean, today, a supplier goes to a house, calls a house, meets with a customer in a kiosk or a retail store, and the customer says, I am the account holder. And the supplier relies on that information. And when they call in, we have this discussion in working groups. When they call into the call centers, to the utilities or to the suppliers, they say, I am the guy who's on the bill. I'm the account holder. Talk to me about my account.
Does the statute provide any exceptions, though?
So
Any defenses?
it does not.
No.
And that's, and again, our position from the outset was, tell us who these customers are, and the suppliers will be responsible for not offering.
That brings us back to the beginning.
Well, it seems like that's honestly the most realistic and safe way to do this. Because then suppliers have the information, and if they make an offer to someone on that list, then, we'll see at the commission.
Ms. Molyneux, have you received any legal counsel with respect to turning over your roles to any supplier that asks for them?
Yes, and I think I've mentioned this under Human Service Article 1-201. We are not able to do that without consent from each and every single customer.
And I would add parenthetically, I don't want any state agency giving my driver's information, my healthcare information, or my assistance information to anybody that asks for it. I think that's a gross violation of privacy.
Right, which is why that law exists. And then also to make a point, we would not be able to include that on the application itself because we would not want to make the willingness or the consent to share information contingent upon benefit eligibility. So it would then have to be something where we came back to get consent from the customer after they are approved, in which case they could still deny consent to share that information.
Thank you, Director.
Thank you.
Excuse me, Director, just to follow up on that, we have in here that one of the options is to check the My OHEP status portal. So did I guess you could tell me your legal advice. Did your counsel suggest to you that you can't proactively give the information, but you could allow the third-party suppliers to access it through the portal? Or is there no distinction?
Through the portal, it's still contingent upon customer consent because they have to give you the date of birth, their last four of their social.
Okay, so even if they have access, they still need, before they even use the portal, they have to first have the last four of the social before they can go in to confirm that the customer.
Right. The portal is a public-facing website where you just need those three pieces of information to find out which benefits you've been approved or not approved for.
Okay.
If I may, Your Honor, I just want to frame very quickly. The way I think of these is the legislation is the house, and the regulations are the fence around the house. So the fence can't be inside the house, right? That doesn't work. You can't give away part of the house. But violation of the law is always going to be violation of the law. What we're doing in regulations is we're putting a fence around the house so that suppliers don't accidentally walk in. They know where the boundaries are that the commission intends to enforce. And that space between the fence and the house, that's where we have remedies of civil penalties and license revocation and the other things that we have in statute. So when we say, for example, that they can't knowingly do this, we're not saying they can do it if they just didn't know. They still can't do it. But we are going to look, or the
Well, who
commission
enforces the law?
So
I think the commission enforces the law.
we absolutely are
But
the
we've
first
we've
line
given them
enforcement.
past a part of that law, so I don't understand that analogy with the fence in the house, because we're saying, well, you didn't knowingly do it. We're not enforcing the law. They did it,
Correct.
and that violates the law.
And they certainly have a contract remedy in court, but they also have a remedy here against the supplier's license.
Look, a 3-2 vote put knowingly in there, but I don't want to keep arguing it, but we can't modify the law. We can't lessen the law. We can't administratively soften the law or lessen the burden. The law's the law, period, full stop. And no matter what words we put in the regs.
But let's not, with all due respect, and I share your concern, if we do the regs dilute from the law, then you can see that argument. Sure, the
Absolutely.
law said that, but here's the administrative agency
how you gonna-
interpreting the law.
How are you going to enforce the law? We're the enforcement agency. We carry out that portion of the public utility article, and we've softened it. How are you going to hit me over the head for doing exactly what you told me I could do? And that's why it's very dangerous to modify the law.
And I just throw in one other point. Mr. Green acknowledged, I was glad to hear it, that really accessing the holy grail here is accessing the OHEP data, not asking the customer. The customer stigma thing really makes that a meaningless alternative. Not meaningless, but it's certainly not sufficient. But the holy grail is accessing the OHEP status. As we know, you've got the last four of the social and the birthday. And yeah, it's burdensome, but that's really the only way to know for sure if that customer qualifies for the protection of this law.
At this time, we will take a lunch recess. I know we're in the midst of considering a very difficult question here. We will come back at 1:30 p.m. We're in recess till 1:30.
was sleeping that first hour, and you did my work, so I owe you.
Thank you.
All right, well,
We are back from recess. We recessed midstream with pending topic. At this time, do any parties wish to continue providing comment on the proposal that we have before us, including the language that Ms. Knoll included, which I don't believe is on the screen in front of us now?
So the purple that's on the screen right now is about methods for the supplier to obtain information related to customer status.
I'm sorry, it looks different. It was one paragraph and now it's been broken into.
Yes, I did restructure it just to make it a little more clear as to what was going on. It was one paragraph, but I've broken it into 3 options for how a supplier could do this.
Thank you.
So I have one proposed edit. In adding an A(4), where a reasonable effort would also include disclosing to the customer that the offer is not available to energy assistance households.
Staff's concern there is, again, we get back to the issue Commissioner O'Donnell raised, the customer stigma issue. I mean, the OHEP status, there's no password, there's no username, you just put in anybody's social or birth date, full last four of the social, and you get it. And going to something where we know it's of limited effectiveness when you've got the holy grail there. The website is open to the world.
It shifts the burden. I'm sorry. It shifts the burden to the customer. It shifts the burden off it becomes an affirmative defense for a wayward supplier, not you, Mr. Green. and it shifts the burden to the customer.
You're referring to
Yeah.
Can I just ask, though, if you just ask directly, or you're going to have to get the information, you're going to have to get that social security number. So either way, aren't you going to have to explain to that customer why you need that information, what they intend to do with it?
Sure, but the beauty...
why
I'm sorry,
not
go ahead.
I'm sorry. So I'm just trying to understand, why wouldn't it be easier just to ask?
Well, the concern, I think Commissioner O'Donnell has I think it's a very wise insight there. A lot of people are embarrassed about that, especially you're in a public setting, other people, at a shopping center. If you go to OHEP, that's 100% accurate 24/7. And yes, it would be an effort for the suppliers to go on that website. They would have to do it for every house they go to, but every customer they speak to. But
Well, I did make sure I've heard this correctly, Ms. Wine and Ms. Peltier. You said you were okay with, as representative of customers, of just asking the question. Is that correct? Or at least the disclosure that the product is not available to OHEP recipients. Was that your position?
Part of it is absolutely have that conversation. The customer should have that agency. Consent should be required, but it shouldn't be absolutely dispositive as to whether or not the law has been broken or not. I mean, at the end of the day, if they're an OHEP, an energy assistance customer, and the supplier has improperly enrolled them into an improper product, that's in violation of the law. It is an attempt to try and, stay within compliance as much as possible, but it shouldn't create, this presumption that no law has been broken.
Okay. Yeah, I'm just, Mr. Chairman, I guess I feel like we just keep going in circles here. We've decided already that we are not going to, and maybe we don't have the authority just to make the lists available.
Correct.
And then on the other side, that we seem to be coalescing around the idea that a customer affirmation is acceptable. So with that, what else can we do? If the customer affirmation in these different steps, it sounds like we want a marketing step affirmation, then we want a pre-enrollment step affirmation, and then a contract step affirmation. Is that correct? Is that where we are right now?
Let me check. I'm not sure on that.
Because
I think maybe the best way to break this down is we have to decide what we want the supplier to do ahead of time. I think that's probably what is our definition of may not make an offer.
So ahead of time is when?
Before they submit the enrollment to the utility, what obligations do what we've been talking about here in the other sections is what do we want the supplier to do before they make an offer or before they send the enrollment to the utility.
Okay, so they approach the customer,
Right.
okay, our potential customer,
Right.
and at that point they talk about the product and then they state that this is only available to non-OHEP recipients.
Correct. And then at that point in time, it sounds like there's concerns that the customer might withhold information because they're worried about that, but that is a risk that the customer might do that. Just that's true, but we are also talking about, I think if we scroll down a little, there's
Then there's
a
another
number
hoop.
4, or right above it, where we're going to put that in the contract too, it sounds like. And so either way, they're going to have, I think my goal, I would say, or what I think is important for us to do here is have something where the supplier is I mean, I know we don't like reasonable efforts, but something where the supplier ahead of time is trying to figure out, am I dealing with an energy assistance customer? Because that's what the law is telling us to do, is they may not offer. So basically our best check is going to be, did you try to enroll that customer? So what efforts did you take before you tried to enroll that customer? We could put into our regulations all these various methods that they can take if that gives the suppliers comfort. But eventually, if the customer's enrolled and we have a complaint, that's when we're going to have the fight over what was a reasonable effort. So we could choose not to define all of this here, and that decision is going to have to come later. We could be silent on the issue, but once again, same problem. The decision is going to come later. Or we can put some statements in here, but I think some of us are a little concerned with, once again, if we're trying to define too much in COMAR is going to basically create this little checklist for us that somebody can just say, I did it, and that's just going to be good enough. So maybe less is more in this situation. But I think it's really, what do you want to make sure the suppliers know before this law goes into effect in terms of what you think is reasonable for them to do before they submit an enrollment to the utility?
Okay, so Mr. Chairman, are we looking for a threshold on the affirmation, or I'm just trying to understand where we're trying to get at this moment, because it sounds like we've also agreed that ultimately the harm, the protection to the potential OHEP customer is that person will be rejected when they go to, be assigned at the utility.
There is that backstop.
Okay,
Yes.
so we're calling it. I hate to call it.
Sorry, but there is an
Yeah.
enrollment. There's a step in the enrollment process by which the utility will reject the supplier's enrollment if they know that the customer is not, if they know the supplier is not eligible to make a low income offer. There is one hole at that point. Nothing we can do about that. It's just we're going to have to deal with it later, which is
Understood, yeah.
Yeah, there is, but
Let's not
that's
go
it.
there again. Okay.
Yeah.
May I ask a question? Sorry. So we're talking about the point in the process where they're making an offer. So they have to, the way this language is, would have to kind of go through these steps before they make an offer and or submit the enrollment information.
At a certain point, you're going to have to decide what does make an offer mean to us, right? I mean, or we could say at the time you're talking to the customer, that's probably when the offer is. But from an enforcement perspective, once they submit the enrollment to the utility, now they're trying to actively get the customer on.
Mm-hmm.
So that's a clear demarcation for us in terms of, did you follow through and go all the way with it? And at that point in time, we would have action that we could take if the customer got through at that point with the enrollment. But you arguably, plain English, would say when they're talking to the customer, they shouldn't encourage them to sign the contract if they know they can't sign the contract. But it's going to be hard. That becomes a he said, she said when it comes to an enforcement action.
And if I may, Your Honor, keep in mind that B1 prohibits suppliers from offering all of these things. But then B3 says that the suppliers can't charge the customers. And so they can't charge them until they enroll them. So there is more space there than just the offer moment. There is also in the statute contemplation of, what happens after the contracting process, which is when the enrollment happens.
Right. I personally think it's better to have more details here to help our folks who have to do the enforcement. I get that, it might create a check the box mentality, like, hey, I did all this. But how about if we said including but not limited to? Oh, we have someone who may have. Stephanie?
Hello, Stephanie Bolton on behalf of the Consumer Affairs Division for the Public Service Commission. Hello, Chairman and Commissioners. So I wanted to jump in here on 3 and alternate 3. As noted previously, there is something in the statute for 308 B that speaks to approval of this. When the Commission has approved the supply offer, retail supplier may not offer to, and it goes on. So we've inserted the language knowingly and the other little 1, 2, 3 as some guardrails for us, for my team, who is responsible for compliance and enforcement, to be able to, I guess, better navigate this new system of regulations. And I think that it's fantastic that you guys are giving us that framework and that we're here talking through what can be done. But rather than the check the box approach, what happens if we just, instead of having alternative number 3 with the knowingly language, what if we just remove number 3 and default back to the statutory language and work through interpretations of the statute? Because at the end of the day, CAD, my team, is going to be interpreting something, and we could be interpreting the statute or we could be interpreting the regulation as best we can. Is that off the table? Removing 3? Alternative 3?
3 was just proposed by Mr. Green, is that right?
I'm sorry, do we mean 3 or the 3 little I's?
All of 3.
All of 3.
And just default back to that statutory language.
Well,
I think that's the only legal thing we can do, but that's just, I think that just my opinion. My opinion is that's the only thing we can do, but.
Well, we've taken a vote on the addition of knowingly to number 3.
I'm in the minority on all of that, but I'm just stating for record, in my opinion, I think that's the only thing we can do is enforce the law. We can't rewrite it.
And that's more helpful to you, Ms.
Yes.
Bolton, to have it be, restate the law without the specificity that we've been trying to work towards on interpretation?
The specificity can be a double-edged sword. And at the end of the day, my team, we're not lawyers, we're not accountants. And sometimes the level of specificity can be even more difficult for us to make sense of than the plain language of the law. I know that's not everyone's intent, and I know everybody's working very hard to come up with a framework that we can apply, but sometimes that's how we feel.
Thank you. So just for the record, your proposal will be to delete all of 3 and every part of 3.
Correct.
So, Your Honor, if we remove knowingly, 3 alone is effectively the language of the statute. A supplier may not make an offer to an energy assistance household unless the offer is associated with a commission-approved contract for energy assistance households. That is the core of the statute if we remove knowingly, and then everything else is additional guardrails.
And staff would be okay with taking out the word knowingly, just as you say, essentially reiterating the directive in the statute, an unconditional.
And I guess just for the record, OPC doesn't object to suppliers asking customers for affirmation, or even disclosing to the customer that the offer is not available to energy assistance households. But I think that both checking the My OHEP status portal or acquiring the pre-enrollment information is a much more surefire way of determining whether or not the customer is an energy assistance customer. So the way it's worded here, I guess my fear would be that the suppliers would get to choose, that they wouldn't have to do all 4, especially with the including but not limited to. They might not need to do any of those 4. They might be able to do something else. But that in practice, they would probably choose to do 1 or Romanet 1 or Romanet 3, and not do Romanet 2, checking the My OHEP status portal, or Romanet 4, acquiring pre-enrollment information, which is the most surefire way of making that determination.
Right. Romanet 1 is effectively just a check the box on the application, which surprises me, Mr. Green, because you said you're not in favor of any of these requirements. Is that right? Did I hear that before lunch? Even the check the box?
We had a very productive lunch. So what we're trying to do is come up with a set of guardrails or guidelines that suppliers know, if I do this, and even if I do this, that there's some energy assistance customers that enroll, have what happens on the back end to my company. And, we've seen the show cause cases, the enforcement actions, the actions at CAD. Even at the very end of the day, if these are mitigation techniques, then we would like them in there, because I think suppliers need the guidelines to know what should they be doing, what is acceptable and what's not. I mean, frankly, if you have what is in A now, you could take out knowingly, because suppliers would know, they know they're not allowed to enroll those. That's in the statute, and that's why we're all here. But there's a difference between someone who takes one of those 4 actions before enrolling, or more than one of those 4 actions, versus a supplier that doesn't.
So you're telling us that you're going to use one of those 4, if you use it as a defense against violating 3. Top line 3.
I think, honestly, whether those are in there or not, that's going to be, if there's a proceeding on, you've enrolled some customers who are energy assistants, the supplier's going to come back with an explanation of, here's everything I did.
He's going to say, you told us to do this and we did it.
We made reasonable effort, and that's codified.
Yeah, so that gives me good cause to violate what the law says.
It's an attempt to comply with the law.
Not if that person is actually on OHEP and you asked them, they gave you affirmation, and you say, well, they gave me affirmation, but I made them an offer and I violated the law, but here's good cause why, and you told me this was good cause why.
Well, first of all, we agree with you that it's very uncomfortable and not a good shopping experience to talk to customers about their economic status, whether they're taking assistance or not. But if you want to get their My OHEP status, you're going to have that conversation with them anyway, because you have to get consent to go into their My OHEP portal.
Yeah, but one of the options is customer inquiry or affirmation.
That's right.
That's all you have to do. Are you on assistance?
I ask
No.
you, are you on assistance? No. Okay, that's fine. You're saying that you're not, but I'm going to have to check it anyway. So give me your last 4 digits of your Social Security and what other information.
So you're
I may
saying
need.
you got to do all 4 of those things?
No, I'm saying if you're going to check the OHEP status, you're going to have that customer inquiry anyway.
Right. But if you're not going to check the OHEP status, they can just give you affirmation and you're clear. You're free and clear. Your street rep said, can you affirm for me you're not getting assistance? And that person who's embarrassed is going to say, yes, I can affirm. Okay, we can make you an offer, and we can give you a toaster. Here we go. And you can use that as a defense.
I'm trying to get to the same point that we're all trying to get to.
I know everybody's operating in
not-
good
not-
faith, Mr. Green.
I'm trying to put a system in place that suppliers can look at and say, I understand how to do business.
I understand, but you don't have an objective position, with all due respect, sir. You're representing your clients. We're all trying to balance it, but I wouldn't. You're trying to protect your interest, and I don't blame you. You should. Vigorously.
Let me say, I will admit that I'm almost thoroughly confused at this point, and maybe for the 4th time, express my disappointment in this statute. This piece of legislation has put the commission and has put all of the parties in a really bad position. I think to date, the informal votes that we've taken have given all of the parties, from the advocates to the utilities to the ratepayer advocate to the suppliers, something to be not happy about. And I suspect that will be the case if and when we conclude today if a vote is called. I don't know if any of the parties in the room will be petitioning your elected officials to change this bad law. I hope you may, including state agencies, OHEP. This conversation has changed dramatically since lunch. I think I heard Mr. Green say that he's okay with removing the word knowingly, which puts him on the same side as Commissioner O'Donnell and Commissioner Linton at this point. I'll confirm that in a moment. I heard our Consumer Affairs Division Director state that she does not require or find helpful the additional specificity. And Ms. Bolton, I'll let you respond to that in a moment. It doesn't feel like we're moving fast, but I am concerned with the ultimate product that will be issued by this agency if, in fact, we conclude today. The retail supply function that we have in the state is the state policy, and I want it to succeed. I suspect this new statute was designed to frustrate both the honest retail supply industry as well as the fly-by-night companies that we've experienced. And I think it's fair to say that these retail suppliers that don't have counsel, that are not in this room today, and that will continue to do and engage in the business practices that they've done, they are not aware of RM 78. They are probably not aware of the state law. I'm personally trying to untie myself in knots to see the bigger picture of what we're trying to get at here. So, Mr. Green, you said knowingly can come out for you if A remains.
That's correct.
Okay, Ms. Bolton, can you explain for me again why you find the statute over these 1, 2, 3, 4 requirements?
Well, I think it comes back to what you said about things being tied in knots. Part of my role as a manager of a team is change management, and there's been a lot of evolution in the law, whether it's by statute, regulation, case law, informal decisions, formal decisions, and it's a lot to stay on top of. And from my team's perspective, if we can keep things more simple, and if the letter of the statute tells us what we need to know, it's just easier to implement in practice. And I know that we're balancing, the needs of, faithfully implementing the law with having a process that we can execute. And I think that the fastest way we can get there is just hit delete on number 3.
And here I was thinking that we were creating these regulations for your team.
This is why I'm glad I'm here.
Me too.
Thank you, Ms. Bolton. We'll hear from Mr. Fitzgerald and then Mr. Trout.
Thank you, Mr. Chairman. Garrett Fitzgerald, State Energy and Climate Policy Manager with Montgomery County. What we see in 3A, we have 4 options, and it's an or statement. I think I find myself agreeing with the comments that we just heard verbally from Mr. Green, that there should be an obligation for the suppliers to verify, to not only ask, but to verify OHEP status, and that should have to happen before a contract should be signed. To me, Roman numeral 2 is the only of the 4 that matters here. I think you could actually make this very simple. All suppliers you're selling to a residential customer, you should have to check through the MyOHEP status portal, and it should be on the supplier to be able to demonstrate that they have done so, or attest that they've done so, to be able to sign someone up. The rest of this is noise. You have to do this no matter what. So it shouldn't be an or statement where you could choose to do Roman numeral 2, or you could choose to do the other ones. That's the one point of certainty that the supplier is able to have in a discussion with a potential customer, where they will know whether or not someone is on OHEP assistance or not. So just codify, you have to do number 2, and you have to show or at least attest that you have. and then you've covered the offer transaction.
And that would occur with every transaction.
Every
in the state.
transaction. It is not, I mean, we see right now egregious behavior on the part of this industry. The whole reason that the statute was written was to deal with that behavior, at least in my opinion. We do not see a couple of bad apples in a field of good apples. We see a lot of bad apples here. So to me, it is unfortunately necessary to ensure that we are implementing the statute as it's written to do that kind of verification across the board. It's the only way that you will know.
I hear you, Mr. Fitzgerald. I am not on home energy assistance, but if Mr. Green knocks on my door, he'll have to run my OHEP check on my sale. And for that, I have to provide him with consent to access the OHEP system. I have to provide him with my birthday. Mr. Green, any other information you need? Last four, yeah. And do you currently ask for birthdays, or do your customers, they do not?
No. They may ask if they're over the age of 18, but they don't ask for birthdays, or they don't know if they ask that. It's usually in the contract.
Thank you. Mr. Trapp?
So I wanted to express my support for Mr. Green's proposal. Taking the word knowingly out of the first part of this is appropriate for reasons that have already been discussed at length. I also believe it is appropriate and beneficial to everyone concerned, to the retail suppliers, to the customers, to the advocates, to the agency, and to the utilities, for the retail suppliers to be given guidance in the form of regulations as to reasonable and feasible steps that they can take to avoid unintentionally violating the statute. And I think that this is, you can ask the question, is this the perfect list of steps? And the answer to that is almost certainly not. But I think we left perfection at the door about 15 minutes into the first day of these hearings, and what we're striving for is something that's the best that we can do in implementing, as you've pointed out repeatedly, Mr. Chairman, a difficult statutory mandate. My client's specific reason for supporting this proposal is simple, and it's the one I articulated earlier. If we are not the gatekeeper, if we are just the backstop, if all we have to do is reject the mistakes that come through, and it's on the retail suppliers at the threshold before enrollment to do this sort of a check, then many of the concerns that I've articulated to you in writing and then over the last 2 days of hearing are substantially lessened, and possibly one or two of them disappear altogether. So this is one area where I, at least on behalf of my client utility, am wholeheartedly in support of this proposal being made by the lead retail supplier representative.
Thank you, Mr. Trout. I'm going to make a proposal to my colleagues and see if we can't move off of this item. Ms. Knoll, you don't need to edit the screen at this point, but I would move that we strike the word knowingly. Notwithstanding the comments of Director Bolton, I recognize that this list is non-exhaustive, and her team may consider other items to determine whether reasonable efforts were made by the retail supplier. So these are just illustrative, these four. Although I would caution Mr. Green, if you come back with just Romanet 3, the disclosure was made in fine print in a pamphlet that would not be sufficient by any means of providing a defense. That is my proposal to my colleagues. Mr. Baker.
I would propose we would just, I think subset 3 kind of, if that's how they want to approach it, that would be in subset 1 or little I. I mean, I'm not saying that it's an acceptable defense, but because I don't view that as an F, I wouldn't even put the including disclosures. It's just I told the customer about it. That wasn't I ask for affirmation that you're not or something. That's not an effort to determine. That's just a statement that that's what this offer is for.
1 and 3 could be collapsed into a single.
So that'd be my only modification.
Thank you.
If it's helpful for that, our proposal is also, and we'll get to it in a couple minutes, that the affirmation comes by way of the contract. There'd be language in the contract where they would affirm that they are not an energy assistance customer for a non-energy assistance contract.
Thank you. We'll see that in a minute. Let's see the language.
You're saying no language?
Yeah, so I think I would say not even disclose. I think customer inquiry affirmation in terms of, because just disclosing isn't enough to say that, because that's now saying the customer truly had to recognize the issue at the time instead of saying, do you affirm? So I guess I would view the disclosing part of that as not the reasonable effort. If you want to leave it, I guess that's staff's position on that issue.
What about this?
Thank you. I think what Ms. Knoll just produced, Mr. Green.
Well,
Romanet I.
One of the reasons for the disclosure on a written offer, is that it's not an offer for an energy assistance household. So they may call in and sign up for it, but it's not an offer that there's a restriction, an eligibility restriction on the offer itself, that this is not for energy assistance households. That's what I was getting at with the disclosing to the customer that an offer is not available to energy assistance households. So I don't know if that edit, that takes away from the intent of why I offered it. I don't know why we need affirmation here. I would delete that.
The affirmation is elsewhere in the contract?
I am going to propose that we put it in the contract, because it's hard to have an affirmation, an oral affirmation or in the marketing context.
So let's strike or affirmation, the highlighted language. Customer inquiry.
Just so I'm clear, are we in the the pre-enrollment section now, or what?
We're in the marketing.
This is marketing.
Yeah, we haven't left
Oh,
marketing
okay,
for
all right.
hours.
I just want to make sure. So we.
Mr. Green, does that work?
Yes, sir.
Okay. That would be my proposal with the knowingly removed. Would commissioners like to share their thoughts, beginning with Commissioner Bubar,
Okay, so we're taking that knowingly.
keeping the rest?
If I may, Your Honors, we may need to make a modification to the intro to 2, because disclosure is not a method of determining their energy assistance household status. So I can work with some language to maybe ensure that energy assistance households are not enrolled on improper offers or something. Sorry, go ahead.
What's the numbering sequence here? 3, 2, what's going on?
So I've moved from an A under 3, so that we're not modifying the statutory obligation anymore, to an additional requirement. I'm sorry, it shouldn't be 2, it should be 4. Thank you. Decided to count backwards. And then we have an A, B, C, and D.
I can live with that.
Commissioner Linton.
I'm sorry, I'm rereading it again for the 4th time. I'm not really sure what 4B. I think was that what you were just saying? A 4B.
The original intro we have been discussing was that these were ways to that the supplier would determine a customer's energy assistance status, but B isn't really a way of ensuring their status. So instead, I've changed it to ensuring that they're not improperly enrolling people.
We need to do a lot of, I mean, I understand the concept, but there's a lot of, we need to clean it up some from an editing perspective. There's several negatives in there, and it kind of, that's why I'm getting caught on it. It's like I've caught at least 4 of them, so.
If your honors are happy with the intent, I can obviously modify wording.
I get the intent of it. It's just, I mean, there's a not enrolled, not limited to, but it's not available, so it's.
Commissioner, if this helps, at this rate, I don't believe we'll be taking a vote today. That will allow some wordsmithing, ensuring all the parallel structure remains. So if the intent is something you're comfortable with, we could fix the precise language at a later date.
Thank you, Mr. Chairman. I am comfortable with the intent. I think the language could be strengthened a bit, but the general intent works.
Commissioner O'Donnell.
So obviously, I'm in favor of taking the word knowingly out, that part of it. But it's still problematic. The whole section is problematic to me in that the law doesn't say, you can't offer one of these things unless you make the following good faith effort. It says you shouldn't offer one of these things, period. Full stop, end of sentence. And this is given a list of things that define reasonable effort. And it's clear to me that some of these suppliers are going to say, you said make a reasonable effort, and I did. I chose one of these. Here's my proof. Now, you asked me to make a reasonable effort. I did, and therefore it's not my fault. They get a get out of jail free card. That's not what the law says. There's no provision in the law to get out of jail free. And that's exactly what we're doing. That's exactly what we're giving them. So, no, Mr. Chairman, it doesn't fix me.
Commissioner Richard.
Yeah, I agree with the intent of where we're going here. I'm still getting a little caught up in trying to understand. Okay, so this is the marketing phase, okay? But it's my understanding that when we get to the enrollment or the contract phase, that we will be doing now it's not Romanet 3 anymore, it's the C. There will be checking the status portal. Is that kind of where we're going with
That's
this?
later in the agenda.
Okay, so before anyone's enrolled, there will be a verification, because I believe that is something that's intended by the law.
That's what that is for.
So this is just to get through marketing. I understand what's happening with D. So why are we we're marketing. Why would the supplier immediately start working on, even consider the pre-enrollment information?
I think Commissioner Richard may raise a very good point, which is this has evolved a little bit away from a marketing obligation and into an enrollment obligation, and perhaps 2053-0705C might be a better spot. I'm just going to scroll for a second for you. So, which is unauthorized enrollment or service. So basically, instead of taking this in the marketing section, we would move it up and say that they cannot improperly enroll these customers. And then we say, this is what we're going to look at to determine whether or not they tried. They still can't do it. But, this is how we're telling them to get it right.
Once you give them that, here's how you do it, and they exercise that, you've lost all ability to enroll even if they do, to enforce even if they do. There's no enforcement of the law. And I hate to speak for the legislature, but I'm sure that the legislature didn't intend that. I'm certain of it, because they would have said so if they did.
I'm simply offering that if the commission wants this language in regulation, this location in 05C may be a better spot for it. That might resolve some of the confusion.
Well, for me, that would be logically where I would place it, because that's where I was getting a little hung up. I'm just trying to imagine how this whole process will unroll. The approaching of the potential customer, and then, at some point trying to make a determination at that point, whether they should even proceed with the solicitation or not. And I think we do that, by explaining that this is only for customers who are not, on OHIP programs. And then when we get to the actual, okay, ready to sign the contract, and that's the enrollment stage, is that correct?
Correct.
Okay, and that's where we would then go a little deeper into
The affirmation.
affirmation. And also, I tend to agree that that would be an appropriate place to actually check the OHIP portal. But in any case, yes, I am good with where we are at this stage.
Okay. Okay. Ms. Knoll, where do we go from marketing?
So, I'm sorry, let me just confirm with all of you. 3 would remain here, and this section 4, because that proposal was made after, Your Honor, Mr. Chairman had made his vote and Commissioner Bubar. So if there are 3 votes to move 4 up to 05C, then we're ready to move on.
I believe there was 4 votes. Is that right?
Okay. Yes. Thank you. Then we are ready to go back to disclosures, which is this is our second time here today. So originally the straw proposal had included simply a statement that if there was a price term in the offer, it needed to include a statement that an energy assistance household cannot be charged more than the standard offer service rate for contracts signed on or after July 1, 2023. The discussion that we had moved that out of the price term section and made it a standalone. The retail suppliers had suggested that the statement should be standalone regardless of whether or not a price term was included, and should only apply to low income or energy assistance household offers. Staff had then, and you can ignore the attribution comment, staff had then suggested that all contracts should have a statement as well that they can't be charged in a market rate contract if they are an energy assistance household.
So the thing that happens with having specific language for disclosures to consumers is that we have to use terminology that consumers will understand. So I guess for a question for OHIP, will consumers know what a energy assistance household is? And is that terminology that you use when you communicate to consumers? And if it isn't, what would the customer, what term would they see? Because that language is really for Comar and for us.
Yeah, I think energy assistance household is going to be the best bet that you could use.
Okay.
Yeah, and that's
So if the customer sees that somewhere in the contract, they're going to know that that section is talking about that.
the other option would be listing out specific programs, and I was under the impression you wanted to stay away from that.
I don't know. I mean,
I proposed alternate language in the second one, which was enrolled with an energy assistance program, which may be easier for customers to understand.
Okay, well, I'm just pointing out that this is prescriptive language for the customer to see. So,
We can also make it less prescriptive. We could just say a statement that, and then the suppliers can work on wording as long as it achieves the goal. I know.
So I'm fine with the section. I don't want to cause more delay in the discussion, but if we're going to continue working on the language, then maybe that's something to think about the best way to phrase it, since we're talking about language that goes directly to the suppliers to put in their contract. And if we're not going to give them specific language, then that probably will make it a little more difficult, because then you can, with the exception of counselor hears clients, they may come up with all kinds of stuff. So I'd actually prefer it to be more specific, but just recognizing that that the average consumer may not know what house energy assistance household is, but that language actually is a little better. Program.
Any objections?
I would object to 3B, that if the product is not approved for energy assistance household, then the supplier should have the discretion to put that statement in if it wants to or not, and shouldn't be mandated.
Say that again, Mr. Green.
B,
I just didn't hear you.
Sorry, B is requiring a supplier that's marketing a non-approved product to put a statement in there that says a customer in an energy assistance program cannot enroll in this product. That may be fine and well, but all suppliers may not want to do that. They may want to take some other method to ensure that it's not a energy assistance customer. So I don't think, in my view, in a marketing material, a marketing piece, they shouldn't be required to make that statement. They ought to be able to have the flexibility to determine the customer's status any other way if they wanted to.
Mr. Baker, I believe you suggested B.
Yeah, I mean, I view B as it's one of the guardrails. It's not necessary to make this work. It's simply a customer. It's basically customer information, customer knowledge, customer education material is probably the best way to look at it. If we want our offers when they're going out to, I almost think of it as having the offer in, or when this goes out, indicating is this for energy assistance customers or not for energy assistance customers, and that would almost be good enough in my mind. But if it's not necessary for this law for it to go in place, so think of it as this was a guardrail that I was thinking made sense. But yeah, to me, I think the more key thing is making sure customers can discern is the offer for energy assistance households or not for energy assistance households. But yeah, I'll stop there.
And it does. I mean, the fact is we've crossed the bridge with offering alternative ways of complying, including inquiry of the customer or OHEP status. So we've sort of loosened it up a little there. I think that makes this guardrail even more significant. It does. It's written right there in the contract that this contract is not intended for an energy assistance customer. So my concern is, yeah, it just sort of making this a little more tight given the alternative options we've given the suppliers for compliance.
So, Mr. Albert, if this was just a postcard to a mass mailer to every residence in the state, the postcard would have to have both A and B listed in fine print?
Yeah, I think that should be specified there. It's another guardrail. The customer can read it and think, wait a second, I'm on financial assistance. Because the trigger is, again, the concern is that we've loosened up the threshold requirements. And this would at least tighten it up a little bit. That's what the law says. We're not adding any new requirements. We're just disclosing the existing requirements.
I am fine with A and B, although I could guarantee that 99% of the public do not read the fine print. But perhaps for the 1% that do, and they know that they're an energy assistance household, maybe that will come in handy. It does provide more clutter, more fine print on the postcards or on the mailers, and it applies one more burden to the retail suppliers who try to earn an honest living in this state. Commissioner Linton, did you support A and B?
Yes.
Okay. Commissioner, I lost the vote count. Did we start with Commissioner Bubar?
No, not on this one.
Okay, all right.
I just want to make sure I understand it. So these two statements would have to go on the example where we're doing a mass marketing. But I'm confused on what I would as a consumer what this would mean to me.
It's
So,
really supposed to be a way, well, hold on, let me read A again.
If I may, do you
Yeah.
mind?
Go for it,
If it's a commission approved, if it's an off or marketing materials for a commission approved contract, it will state that customers enrolled in an energy assistance program cannot be charged more than the utility standard offer service. If it is not a commission approved energy assistance offer, then it will state that an energy assistance enrollee, a customer receiving assistance through an energy assistance program, cannot accept that offer.
I understand that, but I think the dialogue was, but both of these statements would have to be on a mass mailer.
I don't think that you would. I think it's one or the other.
Yeah.
You either have A if your offer is for energy assistance, or you have B if it is not for energy assistance.
However, if there is a mailing that is not associated with a specific offer, call us, we've got great rates.
Okay.
Then you would either need neither or both.
Yeah.
And I have to think that one through.
Well, no, because this is in the pricing section. I think that might be.
No,
so
we've removed it from the pricing section.
roll up a little.
We're in all supplier
yeah,
marketing
disclosures.
solicitation.
Okay, my apologies.
Yep.
So yeah, she's right.
I can support this.
Commissioner O'Donnell.
It's window dressing to me, Mr. Chairman. That's fine.
Commissioner Richard.
Yeah, I do support it. I agree with Commissioner Baker, Mr. Baker, that
Congratulations.
no, I think this is an important customer information, so yeah, I support it.
One day, Mr. Baker will be here.
All right, moving on. We have there was a missing and in this section, which we've thrown in. I don't think it has any meaning for this rulemaking. So this section, which you can all see is very, very long. Minimum contract requirements. So these are the minimum elements that need to be in a retail supplier's contract. So all material terms and conditions include contract services, minimum use requirements, time of use restrictions, clear and concise price description, which has this little Romanet 1 and Romanet 2, a notice that the contract does not include utility charges, billing procedure, acknowledgement of bill and payment information, deposit, if any, description of any fee or charge, a statement the supplier may terminate the contract early, including for these reasons, a statement that the customer may terminate the contract early, including for these reasons, and then under the termination section, which is N, the straw man proposal had nested a Romanet 6, which had included a statement that the supplier cannot charge a termination fee to energy assistance households. And there has been two suggested edits, one from RISA that we delete this requirement entirely, and one from SFE suggesting that we preface, if applicable, a statement that the supplier cannot charge a termination fee. I believe that SFE's intent with the if applicable is that this term would only be included in the offers to low-income households. Including it in the minimum contract requirements would mean that this was then a binding term on all contracts signed after the effective date of these regulations.
Mr. Green, you wish to strike Romanet 6?
So this is not a do or die issue for us, but we just wanted to point out that this goes beyond the statute as far as cancellation fees, and it may be that the commission wants to prohibit all cancellation fees for any energy assistance customer, but that's not what the statute says.
What does the statute say?
The statute, I believe, it's if you scroll down, Ms. Knoll, we struck that, but we tried to be more consistent on 3 and 4 with the statute. I think
So you're looking at T?
I have a 3 and a 4 that says beginning July 1. I think you
Further down.
Oh,
you
there we go.
Yeah.
Sorry.
4.
So it's 4 basically is the.
So
I think what the statute says is that the commission can approve an offer for energy assistance customers that includes a termination fee. You may not want to do that, and you may want to go beyond the statute, but we just wanted to be consistent with the statute on this particular part and just point it out. Like I said, it's not a do or die issue for my clients.
Well, it seems repetitive to have it in Romanet 6N, number 4.
I might not be following Mr. Green's analysis, but it does say that the statute says that beginning on July 1st, 2023, unless the Commission has approved the supply offer in accordance with subsection A of this section, a third-party retail supplier may not offer to, and one of the Romanet 3 says, charge a termination fee to households in the state that have received energy assistance during the previous fiscal year.
I don't want to spend the time to figure it out, but we did a couple weeks ago when we submitted these comments, so I'll just stand down on that particular edit. I don't want to take up everyone's time on this.
I question whether we need both, though. Mr. Auslander, you're saying we need both?
I think that OPC would prefer that that a statement be included, because I think that what this section of COMAR currently does is it explains what statements need to be included regarding the customer's ability to terminate the contract early. So I do think it would be helpful if there was a statement regarding the prohibition on being charged a cancellation fee if they were an energy assistance household.
Okay. Any objection to retaining Romanet 6? Hearing none.
All right, Your Honor, the next edit, it was similar. The next requirement was that all the contracts after the effective date of the regulations include a statement that energy assistance households cannot be charged more than the utility standard offer service rate. I believe, again, RESA had suggested deletion, and I think this is 3 below, correct, Mr. Green?
That's right.
And they had replaced it in this separate section with 3.
Mr. Green, same position?
No, I think the intent behind this was to clarify that this is the beginning July 1, 23 language, and I'm not honestly sure why we felt it needed its own number.
Okay.
Well, it's directly out of the statute, right?
That's correct.
Why are we restating statute again and again and again throughout this? I don't get it.
Your Honor, the intention of the straw proposal was that this should be in the customer's contract, so that if the customer does review the contract and reads it, they will see that they have this legal right. I do not think that most customers read their contracts, but I think even fewer of them read the PUA.
Okay, so this is an element in what has to be in the contract.
Correct. These are minimum contract requirements.
All right, that answers my question. Thank you.
Any objection to deleting R and keeping 3 and 4?
Well, Commissioner, I think the one difference between 3 and R there on the screen is 3 is only going to go into a contract that is for low income at the time. But I believe, correct me if I'm wrong, last week when we spoke, the Commission arrived on the decision that after July 1st, 2023, if the customer ever becomes energy assistance, that they then start to accrue the benefits of this. So therefore the contract does not, the contracted rate that the customer is getting charged by the supplier at that point in time is no longer the appropriate rate to charge them at. I believe that's where we ended. And so if that's where we did end, then I think R is appropriate to keep and 3 should be struck. If it's the other way, then I would agree with keeping 3 and striking R. But I believe we came down on any energy assistance household after July 20, entered into after July 1st, 2023, would accrue the benefits of this statute such that they could never be charged above SOS once they become energy assistants.
And for the record, OPC would like that to retain R.
Mr. Green, can we retain R and 3? Do they coexist?
Right. If R stays where it is, am I right that it has to be in every contract?
I think so, yes.
The statement has to be in every contract.
But Mr.
So if this is an offer for a non-energy assistance household, why would we need to make that statement in the contract?
Because last week, the commissioners, I believe you decided that after July 1st, 2023, if a customer becomes energy assistance, they're going to be charged the SOS. They're going to be charged either a low income rate or SOS. The contract the customer had entered into with the supplier after that date, if it was for a non-low income rate, is no longer applicable. So therefore, they have to get off that contract. And so I think that's what R is. I mean,
that's the law. I just question that whether that has to be in the contract between the supplier and their customer. To me, it doesn't. It's just more wording in a contract that's already, as has been noted, fairly lengthy.
I mean, arguably what staff has proposed in T is getting to the same point, maybe more comprehensively. It doesn't talk about the SOS situation, but it's basically saying that you're going to cancel the contract that's non-low income if your status changes after the fact. I don't know if that.
I would agree with that. I think T would cover it.
Who proposed T?
Staff.
Okay. All right. So T and R. T seems to be more inclusive than even R.
Yes.
So, Mr. Baker, staff could live if R is struck?
Just give me 1 second. I think so.
R includes the guarantee of meeting or being below SOS, which T does not.
Yes,
so.
correct. We do have staff does have language. I'm trying to remember where all the language has fallen out before this. 1 second, Your Honor.
I think Mr. Green is correct that the law is the law and
Right.
it applies whether R is in here or not. It's simply a question of whether or not you want customers to be able to find it in their contract.
Yeah, I think that's fair. So it's a customer disclosure at that point. If you retain T, then R is a formality to make sure the customer understands that. We could. Well, I guess there's one thing. Can you scroll up to 2053, the 04, the enrollment and switch section. Go back down.
This is 53.0. Hold on. It's 53.01. 3.
Keep going down. All right, so as long as you have 3 in this section, then R is superfluous because this is basically stating you're going to charge them the lower of the rates. So I would agree we can strike R because
Okay.
the protection is in COMAR.
Okay. So we'll strike R. The proposal is to strike R, keep 3, 4.
I do think that OPC's position is still that R serves a customer notification function. It's an important aspect of these contracts that are going to be entered into on the operative date in the statute, and I think we would prefer that it be included.
No, noted. Thank you.
Let me ask a question before you go further on this. In T, it says a contract can be canceled early, right?
Yes.
But we didn't adopt anything that at Mr. Green's request that would allow, if it is abrogated early, that would charge an early termination fee. Make sure we haven't done that, because certainly you're not going to penalize somebody who has their contract dropped and is exercising their consumer benefits with a fee that they didn't do anything wrong. They didn't break the contract.
If we scroll up to this one, the statement, because once you become an energy assistance household, you can't be charged the termination fee.
Okay, but I thought I heard Mr. Green saying it goes beyond the law and we didn't want to do that.
I don't know if I misread the law or not, but the way that we had read the law was that it didn't prohibit termination fees in all situations. Maybe it does, as Mr. Auslander pointed out. But
Would you agree with me that we don't want to penalize one of these people?
absolutely.
Yeah, so,
Absolutely. That's why I said it's not a huge issue for us. I thought I was being consistent with the statute. Regardless, I don't
Okay.
have a problem with it.
okay, thank you. I
And
just
Your Honor,
needed to make sure.
There is a later section on cancellation and termination fees that we will get to.
I'm sorry, Mr. Chairman, where did we land on our?
The proposal is to strike R. Staff is supportive of striking R. Mr. Green wants to strike R. OPC wants
Oh,
to keep
okay.
R.
Yeah, because it is an important new customer protection, I was kind of persuaded by OPC that it might not be a bad idea to make it explicit in the contract, just one more place where a customer could stumble on that and, be informed. And, Mr. Baker, I guess I thought that was,
We're okay with having it. I was asked what I was concerned about when I was in terms of striking it was
Okay.
making sure that
but you
staff's opinion is once you become low income, from that day forward
Mm-hmm.
until you're on whatever, you should be charged either you should be charged SOS or lower. And so I wanted to make sure that was captured somewhere. That is captured in our COMARs.
okay.
So I was less concerned about it being in here. But I agree, including it will ensure that it's in a place that customers know to look or know about it. I don't know where else it would be disclosed to the customer. So that might make sense to keep it here. My statement was I was not concerned about striking it though because we did have the protection documented elsewhere in COMAR. So
Okay.
yeah.
So, I guess my position would be on the recommendation of staff and OPC. I would like to keep it in, but
R, okay.
yeah. So
So my proposal was to strike R. Commissioner Richard would keep R. Other commissioners? Commissioner Bubar?
I would agree with striking R.
Commissioner O'Donnell?
Yeah, I'm fine with striking it.
Commissioner Linton?
Yeah, I'm fine with striking it, and only because I think it's covered in one of the other areas.
Okay, strike R, retain 3 and 4.
And T,
I'm sorry, we retained
S-
Romanet 6, so we're striking 4. So retain 3.
and S and T are still in.
S&T we've not yet covered. S&T are modifications from staff. Staff would like 2 additional contract requirements or minimum contract terms. Identification if the contract is for an energy assistance household. We've already talked about that needing to be identified in the offers throughout. I think this is simply consistent with decisions the commission has already made. And then staff has requested a statement that a contract may be canceled early if a supplier can no longer serve the customer under the existing contract between the supplier and the customer as required by PU 84308.
Any objection? These are staff's?
Yes. These are simply, window dressing, I guess, how Commissioner O'Donnell would have stated earlier. But I think I do view T as important in terms of making sure the customer knows that this could change, that your contract could change. So I do think that's a little more important.
Well, I think it reinforces the notion too that it can be canceled and you're not going to get charged an early termination fee.
Seeing no objection.
Okay. The next section that we have is in, sorry, I've gone too far. We have the contract summary requirements, methods of contracting. This is in the Evergreen contract section. So this is contracts that renew basically on a monthly basis. We had a straw proposal that a supplier may not renew an Evergreen contract for an energy assistance household unless the renewal terms match the terms of a commission-approved contract for energy assistance households. These edits, the first edit is that beginning on July 1, which I think is appropriate with other edits the commission has made, and then the other edits are simply wording edits.
Is evergreen contract defined?
This whole section is Evergreen contracts.
It is
It
defined.
may be in the definition section. I don't see Evergreen in the definition section.
So what is an evergreen contract?
It says number 16. Evergreen contract means. Evergreen contract means an existing contract that automatically renews without any action by the customer.
Where's that?
Number 16? In
Oh, you know what?
the
I looked at the
definitions.
definition section of 51. I didn't look
Oh.
at the definition section for 53.
Oh, okay, yeah, I was, yeah, that's in 53.
Yep, it's in 53.
Good enough.
So this simply indicates that beginning July 1, so any customer who is on a variable rate contract, which renews automatically month to month, should not continue past effectively July 31 of 2023.
Seeing no objection.
I just want to clarify what Ms. Knoll just said. So this provision here would prevent a month-to-month contract that was entered into prior to July 1st, 2023 from continuing after that date?
So my understanding is that the month-to-month contracts renew every single month. So a fixed price contract entered into prior would hit this evergreen statute, but the statute itself prevents any renewals after July 1,
Okay, including a month-to-month?
including a month-to-month.
Okay.
And correct me, but my understanding was the variable price contract. Essentially, there's no fixed term because the supplier can adjust the price any way they want. So I think those contracts say, and Brian Green, if you could correct me here, it typically says that either party to the contract, the supplier or the customer, can terminate the contract at any time with a certain 15 or 20 days notice. So it's month to month. We're characterized on like that, and essentially that's what it is. But again, it's a variable price contract that just continues until someone takes affirmative action to end it.
Well, I don't know. I would like to hear from Mr. Green, but I think, yeah, I want to hear from you first, sorry.
I was only going to correct the timing of the notification for a cancellation of a contract. I believe Comar, customers can cancel at any time without having to give notice to the supplier. That law was changed in 2016. Suppliers, to cancel a contract, have to give 35 days notice, 30, something like that.
That's accurate. Suppliers cannot require a notice period. Commissioner Linton knows this well. Suppliers cannot require a notice period for a customer cancellation.
Okay. Is there a question on the table?
Simply the commission's approval of this section of the statute with or without the additional wording.
Oh, I thought we voted on this one already. Seeing no objection.
So notice of contract expiration or cancellation, SFE, as we discussed prior, had suggested that the notice was not required when we covered this last week. So unless there's an objection, I would say that this is rejecting this deletion would be a conforming edit to decisions made last Thursday.
Conforming edits are approved.
So the next section is the early cancellation fee. Commissioner O'Donnell, this goes directly to your concern prior. So a supplier may impose a reasonable early cancellation fee if a customer cancels the contract before the expiration date. A supplier may deduct a cancellation fee from a customer deposit. And beginning July 1, 2023, the straw man originally stated that a supplier may not impose a cancellation fee on an energy assistance household. There have been a number of edits to this section, and SFE also provides alternate language in the comment bubble. So there is the beginning on July 1, 2023, which I think is a conforming edit. And then the wording is changing it to be, if it is not a commission-approved offer, the supplier shall not charge a cancellation fee to an energy assistance household. The original strawman was almost directly from the statutory language. I don't believe that the edits change the meaning. But I'll leave that to Mr.
I hate to do this, but the way I'm reading this with the double knots, double negatives, is beginning July 1st, 2023, if a supplier's offer is a commission-approved offer for energy assistance households, a supplier shall charge a cancellation fee. It's a double negative.
So,
So if I may, because it's Risa's edit, the idea was if you're on a non-commission approved offer, you become energy assistance, so you go either to SOS or to another approved offer, then you cannot charge.
I get the concept.
Okay, that's what we were getting.
The English is incorrect.
Okay, all right, okay. Fair enough.
and this was why the original straw man simply stated that you may not impose a cancellation fee on an energy assistance household.
That's fine. You just can't write it with a double negative. Because that means something completely different than what you're intending it to mean.
I just want to, I'm sorry, Chairman.
Now, Mr. Green, can we write this without a double negative?
So if I may, I'm simply going to reject these very quickly. I can undo this.
Because then it requires
a
fee. Yeah, they don't necessarily want to require a fee on all their customers, I suspect.
So the original straw man was simply a supplier may not impose a cancellation fee on an energy assistance household.
And staff, I'm sorry.
Go ahead.
Staff views this as coming right out of the statute. 4308B13.
Has a double negative in it?
No, but it says you cannot charge a termination fee to households in the state that have received energy assistance during the previous fiscal year.
That's the right way.
We think this applies both to going forward contracts, but getting back to that first issue we touched on, which we will be revisiting on the whole grandfathering, viewed broadly, and it's not entirely clear, we think this would apply a banning termination fees as well to the pre-existing contracts that were in effect before July 2023. It's saying a vital protection for these customers, regardless whether it's a new contract or a pre-existing contract, is that they have the ability to terminate the contract.
Mr. Green, can you live with this?
I can.
Okay. I believe, seeing no objection, we're done with this section. We'll take a brief recess until 3 p.m.
No, you got what you wanted. Now stop. No, I want to start over there.
Yeah.
He has a light.
I know it's hard when you're only covering half of the.
I want water.
Right. And there are some weird, you know. That's not included.
What's that?
Yeah.
Why
Right.
the pre-existing is supposed to?
Yeah.
I mean, it's unclear.
But that's funny to think about the definition, because I like there's been times where I'm like, I could have sworn there was a definition. I've read it somewhere, and then you look and you can't find it. Yeah. For you could have it too. Like for me, I'm just in Twilight Zone.
And whenever I try to assert it, he kicks me in my ankle. I can show you the bruises.
I kick you in the ankle when you keep going.
I can't stop.
I know. Like you won. You won. You won. You won.
I know, but I don't
win.
win.
When you win, you win.
That's not fair. I don't want to win that way.
I want to win after I beat you into the ground.
That's right.
COMAR edit, sorry.
There we go.
Your Honor, we just finished with 2C. In 3, there was an addition of a reference to COMAR 25.30402, which RISA has suggested deleting. Again, I will rely on the very many attorneys in the room, but in 2053-0402, the straw man originally allowed utilities to drop customers away from their supplier. The commission has determined that that is not appropriate. So I believe that RISA's edit is accurate as of the current state of the regulations.
Was that an addition by you?
There is a provision in that section for SCB by which a drop from the utility can occur, but I don't think you need the COMAR for that.
Yeah, I had added that. I wasn't referencing SCB, but we could leave it in reference SCB.
Seeing no objection.
Okay, so we're going to delete. Oops, apologies. All right, moving along. Now we have cancellation of contract for customers who start receiving energy assistance. Recall that this is in the notice section. We've already determined what we are going to do for these customers. This is simply the notification process and the notice requirement. So if you'll recall, a customer goes on to OHAP. The utility has 3 days to notify the supplier of that change in energy assistance household status. A supplier which receives notice from the utility that a customer is newly identified as an energy assistance household shall provide notice to the customer within 3 business days. The notice shall inform the customer that the supplier can no longer serve the customer under their existing contract under PUA 4308, that unless the customer selects a new service provider with a commission-approved contract for energy assistance households, cancellation of the contract shall return the customer to the utility's standard offer service, that the supplier cannot charge a termination or early cancellation fee, and the toll-free telephone number and website of the commission. And then 3 is if the supplier has an approved contract for energy assistance households, the supplier may include in the notice, and this should be in addition to the information above, they may include the commission-approved contract for energy assistance households, including the contract summary and all terms and conditions, and instructions for the customer to provide consent to receive service under the commission-approved energy assistance household. And then the final one, and these are mirroring the 3 opportunities above. So the first one was termination, the second is enrollment on an offer, and the third one is if the existing contract allows the supplier to provide service under a commission-approved contract for energy assistance without additional customer consent, the supplier shall include in the notice the commission-approved contract for energy assistance households, including the contract summary and all terms and conditions. So these are the 3 scenarios that were created above, and these are the notices that would have to go out in those scenarios.
Any parties wish to speak?
I do. I have a couple cleanup items and then one hopefully minor edit. In 3A and 4A, there's it says, look at 3A, including the contract, the commission-approved contract for energy assistance households, including the contract summary and all terms and conditions. I would edit that to say the commission-approved contract for energy assistance households and the contract summary.
And instead of including.
And then remove all terms and conditions.
Correct, yes. And the same thing up in 3A, and then in 4, the first line allows the supplier to provide service.
Can I go back to 3 a second? 3 is if the supplier has a commission-approved contract for energy assistance households, the supplier may include it in the notice. Why is it may? Why is it like optional? Why are we putting optional language?
So and some of these are conforming edits. So the reason that the straw man selected an A was because the supplier may not want to enroll that customer on that offer. And they are not required to make that offer to that customer.
Understood. But if they are going to have to give notice, which in this section they are, why are we saying they can decide if they want to stick this language in or not?
Just to make sure I'm following, so this is for contracts that are not approved and the customer becomes energy assistance
No, this says
eligible.
if the supplier has a commission-approved contract for energy assistance households, the supplier may include in the notice.
So the scenario here is the customer's on an unapproved market rate contract, and then they become OHEB. This is the contents of the notice that goes out in
understand.
that instance.
I understand.
So,
But understand how I read may. I read may as may not.
correct.
May or may not.
They may not include the offer to that customer.
No. That modifies the notice, not the contract. I understand they may not offer the contract. This is the notice.
Ms. Knoll, the intent of 3, is my understanding is the intent of 3 to ensure that if the supplier wants to enroll them on energy assistance household, that they will include this information?
Correct.
I think we can accomplish what you want to do with 3 with some slight modifications. And to
Would
answer,
you agree that currently
I see what
they
you're.
may or may not
yes.
notice people?
So if the
No.
supplier wishes to enroll the customer on a commission, enroll a contract through this notice, they shall include
So-
the following.
I think you solve it by changing may to shall.
Right, I
Well,
think, go ahead.
So 2 is, so 1 is that they have to send a notice. 2 is required contents of the notice no matter what. 3 is if they have an approved offer, they can send that with the notice, but they don't have to. But they have to send the notice in 2 regardless. And then 4 is if they are not required to, obtain customer consent, they still have to send them the contract.
Okay, so you're saying A, B, C, and D are mandatory elements of the notice.
In every instance, every customer will receive A, B, C, and D.
Okay, and
If-
then 3 could say, I think as Mr. Baker suggested, if the supplier decides to offer a commission-approved contract for energy assistance, they may include in the notice bump and bump.
Yes.
Okay.
And that's why I put the may, is because the supplier can decide if they want to extend that offer to the customer at that time or not. But the notice
But-
has to go out.
But if they decide to offer this, sorry, if they decide to offer this approved contract, shouldn't they be required to send those notice elements as well?
Yes. And the way it's written is, under 1, they're required to send the notice. Under 2, these 4 elements have to be in the notice in all instances.
Right.
And then 3 is they may provide this additional item. And 4 is if they don't require to obtain consent, then they also have to send the contract.
Yeah, but I still think it's worded, I understand what you're trying to accomplish. I still think it gives them optionality with regard to the notice. If they're signing them up on an approved contract, they shouldn't have optionality in the notice. What's the utility of sticking that in?
So when we structured the section above about what happens when a customer is newly identified as an OHEP recipient, the supplier had 3 options: terminate the contract.
I'm not opposed to the concept here. Could I ask, Mr. Chairman, that maybe they work on some language? I think Mr. Baker understands my concern.
well, we won't get stuck on that point. Ms. Knoll, did you have more to say on this?
No.
Commissioner Linton.
Thank you, Mr. Chairman. I just had a question. I was wondering, I see a 4 and an A, but it's highlighted differently here. Was that part of the straw man, or is that language?
No, the yellow is created after the last hearing in line with what you all did as far as the supplier's options were concerned.
Okay, I wanted to make sure there wasn't a B, because I see 4A.
No, there isn't a B, and probably that should move up, but I was just structuring it the same as the other 3 sections.
And one clarifying question I have is I know that when we talked about the options that a supplier is going to have, that we had made an edit and given them 5 business days to exercise one of the options. I know that isn't necessarily the same as the 3 business days here, because this is talking about how long the supplier has to notify the energy assistance household. But I just wanted to bring that to the commission's attention, because essentially if they waited 3 business days to do it, they would only have 2 business days under the other rule that has been tentatively approved to finish the process, which is not necessarily inconsistent, but I just wanted to point that out.
So, Commissioner O'Donnell, do the edits to 3 satisfy you? So they may include with the required notice. So it makes clear that the notice above is required, that it's optional whether or not they put this in the same envelope.
If the supplier has a commission-approved contract for the assistance households, may include with the required notice. I think it still says the same thing. Except you added the word with required? Yeah, I understand what you're saying there, but the part I'm concerned with is the may.
Well, but if we make it shall, then they're required to make that offer to that customer whether they want to.
But I don't want to do that. I'm not suggesting that. I'm suggesting something else. I'm suggesting that if they decide under their discretion to offer that contract, they shall give this part of the notice. Not they may give this part of the notice.
This is separate from the notice. This is the making of an offer to put them onto that contract.
It's talking about the notice, including information.
Commissioner, here's some proposed language that might be able to do what we're thinking. In addition to the notice required in Section 2, if the supplier wishes to offer the customer an energy assistance household contract, then the supplier shall include all the relevant information to enroll the customer as an energy assistance household customer. And then you can strike everything after that, because they have to give them everything that's required to do it.
That'd be fine. That would fix the problem with the structure, because I know you didn't intend to give optionality on notice, but that's what it was doing.
Right.
Giving optional, discretionary notice requirements.
This is very heavy wordsmithing. I'm sorry, but could we just change the word wishes to something else? I mean, sorry, I just chooses, may, I don't know, something. I don't know. But I don't feel like it.
Any other edits or suggestions to G? Hearing none.
All right. Section 12, assignment of contract, originally had no red lines, but staff identified a new section E, which creates a requirement that the suppliers shall not transfer a customer with a contract for energy assistant households unless the receiving supplier guarantees continuation of the customer's energy assistance household contract and is approved to do so by the commission. I think the intent here is to ensure that if a supplier has energy assistance contracts, that after any assignment of the contract, the customer still retains that same protection.
Perhaps, Mr. Green, how often does this happen?
Assignments happen quite frequently, and that's why we actually implemented this particular COMAR provision in 2016. But I would point out that one of the, in 12A1C, there's a notice, a joint notice that goes to the customers from the two suppliers in the transaction. Part of that has to include a statement to the customer that the terms and conditions of the customer's contract at the time of the assignment shall remain the same for the remainder of the contract term. So I'm not necessarily opposed to the new F, but it's redundant.
What item is that we're looking at on the screen?
Right here.
C.
Okay, so there's a joint notice that goes.
Shall remain the same. Okay, I find this is redundant. F is redundant. Any objections from the table? Mr. Aslander, it looks like you're about to speak.
I think, and this is not my proposed addition, this is staff's, we did support it, but I think that maybe what it's saying here is that not only this isn't a normal contract assignment, this is also a situation where the supplier is supposed to have gone to the commission and received approval to act and to offer energy assistance contracts. So I think, and I guess Mr. Baker can correct me if I'm wrong, but I think that is what I understood to be part of why this section is needed and why it's different than what is currently contained in the rule.
Let's
Right.
hear
Yeah,
Mr.
so
Baker.
I think there were two parts to it. One was the continuation of the contract, and thank you, Mr. Green, for pointing out the part before that. I had missed that. But the second half of it is we're supposed to be approving these contracts for the supplier who's offering it. So unless that supplier is authorized to make the offers as well, and I guess that contract, we have to do something to state you're authorized to continue making this offer.
Even at the same terms and conditions?
I guess I'm not exactly sure how we're going to review and we have some ideas of what's going to go into this review process right in the beginning. But if there's going to be anything, if all we're going to do is just look at the terms of the offer and that's that, we're not going to look at the background of the supplier or anything like any such action like that, then maybe it's not a concern.
Okay.
But if we were going to include anything else in our review, then you might want to have to approve that supplier to take on those kinds of contracts ahead of time.
Mr. Green, did you envision that the commission would have to approve the offer from the second supplier, even though it was the same offer as the first supplier?
I did not. I hadn't read it like that. I thought it was just simply guaranteeing continuation of the existing contract after the transfer.
I tend to agree with you. Mr. Trout.
So, my concern is similar to Jacobs and Ben's in that if the utilities have to know who's got approval from the commission to offer a contract to low-income suppliers, what we're going to be working off of presumably is a list of approved contractors. And so the contractor who's accepting the assignment's got to get onto that list, or we won't know that they're approved to serve the new customer. And this may not be the only or the ideal mechanism for making sure that the that the supplier accepting the assignment then gets on the list, so that we, the utilities, in order to perform whatever functions it is you assign to us, know that they're an approved offer supplier. Somehow they've got to get on the list that gets given to us.
So you see a distinction between F on the screen and
For staff, that distinction in terms of the second half getting on the list is the very last sentence, and or the last couple words, and is approved to do so by the commission. That's the distinction there.
Yes.
The first half of the section, I agree with Mr. Green, that is redundant.
Ms. Wine, did you have?
Oh, I was just going to point back to the language of 4308B1, beginning on July 1, 2023, unless the commission has approved the supply offer in accordance, and then it has the subpart. So it does very specifically tie these to commission-approved offers.
I think you can strike and just see is approved to do so by the commission.
There might be situations where a particular supplier may become a higher violation that could be trusted and probably did.
I think we may have to do a little bit of wordsmithing.
Okay.
It probably is approved to provide contracts for energy assistance households by the commission.
Any objection to the intent? Seeing none.
The only question I have is, Mr. Chairman, and I apologize for getting hanging up on this, but it's the offer. Is it the offer that is approved, or the supplier being approved to make the offer? Because if it's the former, then as long as the terms and conditions of the contract stay the same after the transfer, then it should be over.
Mr. Alpert, Mr. Baker, we're approving the supply offers, not the suppliers. Is that correct?
My understanding, though, the supply offer is tied to a specific supplier. There's not a, my understanding of the law, the intent, there's not a generic supply offer that people can opt in or out. It's an offer from a specific supplier. So, yeah, it could be that several suppliers may well use the same offer, but each of them has to come in to the commission and have it approved, so they get on that list of approved suppliers.
I was going to say the law is vague. It does talk about supply offer, so that's in B1. I think, though, practically we're going to have to put them on a list so the utilities know that supplier can do this. Otherwise, we're going to have them getting notices saying, hey, you have a bunch of customers that you shouldn't be serving. And so that would be that practically we're going to have to do something about that. So I think this F memorializes that. I'm not sure.
I think Mr. Green raises a good point, but council raises a good point too, and this is yet another wart on this poorly drafted piece of legislation. Mr. Trout.
No, I was just, again, agreeing that you're right. The statute talks about offers, it doesn't talk about suppliers. But the way these regulations implement the piece of this that is assigned to the utilities is we get notified as to who the suppliers are who are authorized. We are not looking at every single supply offer to every single low-income customer. We are tasked with looking at, is the supplier on the list or not? So that's my understanding.
Your Honor, for consistency, I've modified to say that the supplier shall not transfer a customer with a contract for energy assistance households unless the receiving supplier has a commission-approved contract for energy assistance households.
No.
Because that's the only list we've created thus far in regulation is suppliers that have an approved contract for energy assistance households.
That ties it back a little closer, Ms. Knoll. You raise a good point, Mr. Green. I don't think we could help you out here. Contact Annapolis for us. Ms. Knoll, where do we go from? Oh, sorry.
I'm sorry.
Commissioner Linton?
This is, yeah, it's definitely a wart. A wart is a good word for this. I almost don't want to ask. Never mind. I won't ask.
Make sure that flows.
Your Honor, the next section is also an additional section where the straw man had identified no changes. But staff has provided a new E, which states that a supplier may charge a rate lower than its stated rate in a contract for energy assistance households without notice to comply with the law. So this section is the written notice requirement of changes in rate, and staff is effectively waiving the written notice requirement where it is necessary for the supplier to reduce their rates in order to comply with PUA 4308. The only thing I would suggest is that we specify PUA 4308 here.
I suspect there's no objection. No objection.
All right. This may be very close to our last section. So this new section in the Consumer Protections 14 is for energy assistance households. The intention of this section was to outline how we were determining whether or not a rate was at or below standard offer service, or when we get to gas, the applicable gas default rate. So A includes the requirement that an energy assistance household may only be enrolled by a supplier onto a commission-approved contract for energy assistance households. One is a utility receives a supplier enrollment. The utility shall determine the customer's energy assistance household status and reject the enrollment if the supplier does not have a commission-approved contract. There is an edit here, which includes when rejecting an enrollment, the utility shall identify the reason for rejecting the enrollment as the customer's energy assistance household status. 2 is the utility shall record the number of rejected enrollments and provide annual reporting to the commission. And then A and B are the utility reporting obligations. And then 3 creates supplier reporting obligations. And then as we go into B, we get into the actual rate comparison. So 1 in this section creates the utility obligation to reject enrollments. The edit from RISA creates an obligation for the utility to identify for the supplier why the enrollment happened, or I'm sorry, why the rejection happened. And maybe we can just handle those 2 before we go into the reporting.
Any discussion from the table? Commissioner Richard.
I mean, this is basically a checkbox, right? It's a non-compliant contract. I guess I'm trying to figure out how much explanation is needed here.
I'll let Mr. Green go. I think the only question that I would see is whether or not the RISA edit that the utility has to identify the reason has any implementation cost.
So just to level set, I think last Thursday it was decided that if there is a rejected enrollment for energy assistance purposes, suppliers will have 2 weeks to notify the customer that their that their enrollment was rejected. So we need to know when that happens. And when the supplier sends the EDI transaction to the utilities, they all have numbers, 814s, whatever they are. If the enrollment is rejected, the utility will send an EDI transaction back to the supplier noting the rejection, and will have what's called a reason code attached to it. So I don't know how difficult it is to program, but all we're asking for is that when the EDI rejection comes back, that it have a reason code associated with it, so that the supplier knows there's been a rejection for energy assistance reasons. I'm on the clock now. I have 2 weeks to send a notice out to the customer.
Staff would agree with Mr. Green, also because the COMAR that we have proposed in 2053-04-02 I states the supplier shall inform the customer if a customer's enrollment is rejected for the reasons specified in G or H. So we would have, arguably we don't need the language because that already requires it. But because they have to give the reason, that code will have to exist. So this language is technically repetitive of what we're already going to have to require. But in terms of the intent of what you were trying to accomplish, the COMAR is written such that we will have to create that code.
So in this circumstance, would there be any other reason other than this is an OHEP, this is now an OHEP recipient?
In customers in energy assistance household and this, no, there'd be only one reason code.
Okay,
But there may be other reason codes.
Well, the reason for the rejection of G or H, so G is the SCB rejection. We were creating 3 codes for that. And then for H, we state that we will reject you, and 2 conditions have to be met because it's an and.
Okay.
Customer energy assistance household and the supplier does not have an approved contract. So we would have 1 rejection code because both, we're not, I mean, I would not suggest that we create 2 for an and statement.
I apologize. I thought your question was, are there other reason codes outside of this energy universe, the energy assistance universe that we're talking about? And the answer to that, I believe, is yes.
Okay.
So we would need to know why it was rejected. It could be for a number of reasons.
Okay, I thought in this case it'd just be one.
No, there's
one reason.
we already
one
have,
only.
this is already a practice today. We would be adding another, which will add a cost, as I think I might be hearing.
We got the utilities lining up. Miss Beckham.
For the cost, right.
I just wanted to, I think there was a question as to what the cost would be to be able to provide the reason for rejecting enrollment. It would require, I think, as Ben was saying, creating that new EDI code. And depending upon how complex it would be, there would be a cost. We don't know the exact cost, but there is going to be a cost. I just want to let you guys know that.
$1 million. Mr. Trout.
I was going to start in the same place, which was if we already have multiple existing codes, this just means adding a new one. And I agree with Ms. Beckham that there will be some costs associated with that. I don't think it's going to be major in terms of either cost or time, but it does. There will be a cost. And so what this does is has us rejecting an enrollment, and so that's not not interfering with an existing contract. It's preventing the formation of a new contract, and I don't know how that figures into the concerns that Commissioner O'Donnell has raised on several occasions, but I just point out that that's what we would be doing. And then I will reiterate that we would only be able to act on information that we have. So if the customer is receiving energy assistance for our type of energy through us now, we would know that. We would know that for the current year. And if they were receiving energy assistance for our type of energy in the prior year, presumably we would know that as well. Anything else we would not know. So gas isn't going to be able to do electric. Electric isn't going to be able to do gas. Neither of us is going to be able to do propane. If somebody has moved service territories even within the same energy type, we aren't going to know that. And we're also, and all we're going to know is the supplier on the list or not whether this particular offer is the offer that the commission has approved. So with all of those limitations and holes, if you order us to do this, we can do it. And this particular obligation, I don't think is going to be outrageously expensive.
Thank you.
Mr. Trout, let me just tell you that my concerns stated previously with regard to abrogation of contracts by utility that are actually owned by a supplier is different than this, because in this situation, as I read it, there is not a commission approved low household income contract. So it's not a legal contract. Even if you consider an enrollment a contract, and the word used here is enrollment, my same concern doesn't exist because it's not going to be legal if it's not approved by the commission.
I understand, Commissioner, and I'll add one thing further, which is why I'm not saying any more on this topic in the way of a protest, is that the way, assuming the rules get approved as you have now revised them going along, this is not the customer's first line of defense. This is the customer's second line of defense. We are no longer the gatekeepers. We are the backstop. And we will do a good job, or as good a job as we're able to do, given all the limitations I've pointed out to you, as the backstop. But this is no longer the customer's first line of defense. The first line of defense is the retail supplier is going to do that inquiry up front, and they're hopefully not going to send us very many enrollments that we would have to reject.
One would hope not, since the COMAR is going to say they have to have and the law says, to be honest with you, that they have to have a commission-approved contract. And if they don't have one, they don't have one. They're breaking the law. If they enroll somebody.
That's A1. Seeing no objection, A2.
A2, the straw man proposal simply required that the utility record the number of rejected enrollments and provide annual reporting to the commission. It was not included in statute, kind of what particularly was recorded and what was required. I'm sorry, not included in regulation. Looking at 4308, 4308D1 creates reporting requirements for this commission. On or before September 1 of each year, the commission shall publish a report on the commission's website that includes 6 pieces of information. So the regulation simply required the utilities to record and then be able to send that to the commission. OPC's edits create a number of reporting obligations that are, some of them, I'm going to go through them in order. So 2A, the total number of submitted supplier enrollments that were denied because the supplier was not approved to serve energy assistance households, that is directly from the statute, that is numerat 5. B, the total number of customers that were returned to standard offer service under COMAR 25302K1A, that is not from statute, but that would begin to get at that question that we had earlier about what if suppliers are not actually dropping customers when they receive notice of new OHAP status. So those two are utility reporting obligations. Does the commission want to go to the supplier obligations or cover those two initially?
So OPC is adding a non-statutory reporting requirement in B?
Correct. But this was alluded to and discussed earlier about how do we know if the suppliers just aren't complying for newly identified OHAP customers. This reporting requirement would shine a light on that.
Ms. Beckham?
So for Part B, we actually, I think that may be just a carryover language from the automatic drop. Because remember, we're just going to be sending the notification that they've been dropped, but we won't know why they're being returned to standard offer service. Does that make sense?
You won't know why, but we just approved a requirement requiring the utility to explain why.
That's a different requirement.
Oh, sorry, different requirement. Okay.
So if an enrollment is denied because the supplier can't serve them, the utility will effectuate that. 205302K1A references where a supplier submits a drop to the utility in response to notice that that customer is newly enrolled in OHAP.
We'll just receive that drop. We won't know why. It could be just that the customer may not be on energy assistance, but said, we no longer want to be with the supplier.
But you record that?
We will have the drop, but we won't know why.
Okay.
If it's we won't know if it was because they're receiving energy assistance.
But you could comply with 2B. You could tell us the number.
I think it's the issue with the under COMAR 20.5302K1A. I think we could say who's been dropped.
Within a certain time frame of the notice sent out under.
I think B was relevant when we were still requiring the utilities to effectuate drops. But now that we are not, I don't think B is relevant. I think more importantly is going to be a report from the utility, I think the gold standard for us to know if suppliers are complying or not is we're going to need to know what price was charged to the low income customer and what price would the utility have charged but for them being with the supplier. If we have those two pieces of information, then we're going to know if customers are actually paying more or less than they should have paid. And so I think that was honestly what I'd want from the utilities is a report that, one, what price did you charge each customer? And two, what price would you have charged if they were with you on SOS? That would be the gold standard for us being able to check these on the back end. That might be burdensome for the utilities, I recognize, but I think if we're going for the trust but verify aspect of this, that's the gold standard.
So the issue is we don't receive the price that the suppliers would charge to the customer. We just get the total.
I would say, yeah, I guess what I'd be looking for is what you charged on behalf of the utility. Sorry, what the utility charged on behalf of the supplier and what the utility would have charged, so not the price, the total bill. I think that's what we'd be looking for.
And to be clear, nothing in the regulations right now requires the utilities to look at the supplier charges that are being placed on bills.
Correct.
Aren't we, by doing that, aren't we putting the utilities in the enforcement role?
We would be putting them in a reporting role for us to be able to do enforcement. So it becomes a question of, I guess the real question that we should ask ourselves with these reports and what we want to ask for in these reports is going to be how we want to enforce the suppliers in our market. Is it going to be we're going to wait until we hear from a customer that they're being charged inappropriately? Okay, we probably don't need most of the reporting. Or are we going to do a periodic check on the markets, in which case that's going to require more information?
So I want to hear from the utilities, but I think I keyed in on we need to know whether or not the suppliers are complying with the requirements with this information. And I don't think the utilities are going to do that analysis.
Right. I don't think we're asking them to make a factual finding. I think what I would be asking for is what price did the customer pay, or not price, what was the total bill they paid, and what's the total bill they would have paid. And then it's our job to determine what to do with that information at that point. That would be the request to the utilities.
And I think our response is it's entirely it's very burdensome because there's the cancel rebill issue, as well as, like I said, we won't know that price that the suppliers are offering. One thought is, how about the suppliers provide the information as to the price that they're offering?
I'm not interested in the price. I don't care I care about the total bill at the end of the day. I mean, the price, I guess, matters. I could look at the price they charge versus the SOS rate. That could be a way of doing it, but the total bill is what the customer paid, I guess. So I'm not talking about price, I'm talking about total bill.
The total bill will include those utility charges.
Yes.
Okay.
Mr. Trout?
So I admit to being a little confused because I don't see any language in describing the new utility obligation that Mr. Baker just discussed. But assuming that there were a proposed C with some words to it that said that we were going to give information that somehow compared prices paid by customers under supplier offers to SOS prices. Let's take it A, B, and C. For A, we can do that. For B, for the reasons that Ms. Beckham has already detailed, we simply would not have the information necessary to do that. And for C, we are able to report our SOS prices or bills of customers who are receiving SOS service over some designated time period, and you would need to write the language, preferably not as we stand and sit here now, but you would need to write language detailing what it is you want us to report. But if you're going to compare that to supplier bills or supplier prices, we don't have that, and you would need to get that from the suppliers. So staff would have to get two pieces of information from two different sources and then do the comparison themselves, as opposed to having us reporting on supplier information.
Thank you, Mr. Baker. Mr. Trout just said there's an imaginary 2C that you were discussing, but it's not before the commission.
I was basically saying, yeah, yes, I agree with him. There's not, I think now with where the commission has gone with, we're not going to use the utility, basically utilities are not going to stop. We're not going to have a step in there where if the supplier does not take action, we drop the customer. The question I have is, okay, how are we going to enforce our markets to make sure that the suppliers are following the law and not overcharging low-income customers? There's two ways we can do that. One, we wait until we get a complaint, and then we look into it. We do data requests. We have an enforcement action. We're going to have to involve both supplier and utility to figure out what the customer should have paid. But that means that we're waiting until the harm has happened. The next option, which would be more rigorous and it will be more burdensome on staff, the utilities, and suppliers, is we would have ongoing reporting requirements about what customers are paying in the market versus what customers should have paid in the market. And that would help us determine if we have an overcharge occurring. I guess what we could do is say, what's the price? And then the suppliers would tell us what price they charged. I guess that is a way of doing it. I was thinking of it more from a total bill perspective, because that's going to tell me what was actually billed to the customer and what the customer would have actually been billed. It's a much easier number to compare versus now we're talking about prices and what went into a price. But I'm okay with either, but I think my goal was for the bill. But I agree with Mr. Trout, they could not give us prices. They could give us total bills, and I was asking, I agree, a burdensome request for them to do math on what they would have charged customers. So I think that was my gold standard request. As I stated, there are lesser standards that we could hold it to. But I think either way is a question for you. When do you want us to start, or CAD, to look at our markets and determine our suppliers complying with this law? And I think that will then determine what level of reporting requirements we're going to put here.
Mr. Baker, all of these redlined requirements came at the request of OPC, is that right?
Yes.
2B, we just heard from Ms. Beckham, perhaps Mr. Trout, that they don't have the information to provide us with.
And I would agree. I don't see how they would have that either.
So I would move that we strike 2B. You raised a good point on the broader issue, Mr. Baker. The burdens, the benefits of receiving this information, the burdens on the utilities of having to do the math, do the research for us, deliver it to us for analysis. Resource intensive for sure, versus the old-fashioned way where we wait for complaints to get filed and address them on a case-by-case basis.
Can I ask a question on that? So if we went with the more proactive approach where staff would be asking for or getting information and looking at it proactively instead of waiting for a complaint, can you just clarify what you would be asking the utilities to submit? You went through multiple scenarios.
Right,
Well, let's
yeah.
go with the price scenario as opposed to the total
price
bill.
scenario, I don't even know if we need to put in a requirement at that point. It would just be what rate would you have charged. It's effectively what's the SOS rate that would have been charged to the customer. I should be able to either get that or I send them a simple data request saying what were your rates at these various times. That's simple, I think, for the utilities to comply with. They can chime in on that. And then then the next half of that is I would have to go ask the suppliers, and that would be in these reporting requirements, to tell us what prices they charge customers. So I'm relying on their information to make the determination that's okay. I think that's a baseline way of doing this. There's a second one that's more rigorous, and where you could ask the utilities to do work for us, but then that's what we're asking them to do is perform analysis, and I agree there's going to be a burden and a cost there if we do that.
So what I was trying to understand is if we went with the model where the staff says we'll take on the burden of doing the analysis, but focusing on price, how would that compare with the additional information that OPC put in there in terms of?
I think most of that's covered here. Give me a minute.
So we haven't gone to 3 yet, which is the information from the suppliers.
Right. I think what you're going to have there is the suppliers are going to tell it. I think there's a requirement under 3D. The the rates charged to each energy assistance household each month during the 12-month period. That would be the price check. So that does exist if you want to just do a baseline price check. If you want to do more than that, then we would have to add to this. And
The chairman provided, just to keep,
yeah, sorry.
just to keep us focused, 2A, the chairman had proposed that we delete B. He had made a motion to do that. I didn't hear any additional input from any of the other commissioners. Is 2A sufficient for what the utility obligations will be?
And 2A is the law, correct?
2A is the law.
And is it adequate information for staff and the other parties is really the question.
I would say under B, I mean, I have my request on the prices, and I guess really what I was looking for is bills. But the other thing that is not related to that is the number of notice. I guess there's the second part to 205304, where we tell the supplier, hey, you have a low-income customer. I think it would be good. They don't take any further action. It would be good to get a report knowing how many of those were sent each month to the suppliers, and preferably to which suppliers they were sent.
So,
And who would provide that information? Would that the utilities be able to provide that information pretty easily?
They're going to be doing they're going to have to send the notice, so their system they would have to set up their system to record they sent it, but they should have that.
And would that provide our staff with, I guess, a flag that we better check into this? You know, we have.
It would tell us which suppliers to at least look at to see if they did what they were supposed to do. It's
Okay.
not. It wouldn't be enough to determine if they followed the rules, but it would be enough to know who was told, informed of the issue.
Would that be a first good start, though? I mean,
Yes, I think-
again to see if we can, again, I guess ascertain the compliance that's
Right.
taking place out there to make sure that suppliers aren't just ignoring the notices and aren't following and if they are not following through with the drop.
Right.
Because
Yeah.
that's ultimately we're trying to quickly.
And then
figure
what
out.
we would have to, I mean, the next thing we could ask of the utilities is for those accounts of which you sent notices to the suppliers, how many were dropped back to you? I mean, that would be the secondary question I would have of the utilities. I would also have a question of the suppliers, and I'd probably put it under their reporting requirements. Every time you received a notice, how many of those, which customers did you send back? How many? Give me a count.
Okay, and that would allow our staff to
That'd be
have
a first
degree
step.
of proactivity as far
Yeah,
as.
and I think staff would have to think, staff has not thought about how we would do enforcement, if it's our job to do enforcement, if that would live with CAD, or even if we want to do enforcement on this, following this manner. But since we went the route of trust but verify, I think we're going to have to consider as a commission how we're going to check the markets for compliance, or do we not want to and just simply wait until there's a CAD complaint? That's your other choice. But I think if we want to be a bit more proactive, this is the information that we need to gather.
Okay, yeah, I would agree. Ms. Billett, do the consumer advocates, do you have anything to say? I know that was something, about reporting we discussed earlier today.
Staff captured it. The extra, if we're not going to get the detailed pricing data, the preliminary data for the notices sent out and the drop from the utilities is a good starting point.
Okay, and for OPC, would that?
Yeah,
provide you-
I would add that as worded right now, and I know we're still sort of trying to work out the language. I guess it would be the notices sent and then to which suppliers, because otherwise we don't just want to know how many notices you sent to dozens of suppliers, but how many notices were sent to each supplier, and then information about the number of drops. I guess, and I guess what we would expect to see is that there should be some level of drops associated with those notices. But there are going to be cases where the supplier may, at least it's possible, that the supplier has an approved offer. So I do think that the pricing information that Mr. Baker referred to is, I guess, the direction that OPC would like to see us move in, at least early on. If we know after 2 years that no suppliers ever submit offers, to never seek approval to serve these customers, then all we would need to check each year is the number of notices that went out and the number of drops should match, right? because
Okay.
there would be no approved energy supply offers. But I think I share some of the concerns that have been alluded to by the commissioners and other parties, that there might be some problems with compliance, and especially in like the first year or two of the implementation of this statute.
Can we use the term return to SOS instead of drop? That sounds a little bit close to slam back to SOS and sensitive terminology in this area.
All right, Mr. Fitzgerald, then Miss.
Oh, I was just going to finish up.
Oh,
just
I'm
to
sorry.
say, yeah, it sounds what I'm hearing that this is probably the minimal information that we need so our staff can be proactive. So I think we do we have language already before us that would get to that?
I think Ms. Knoll is typing it as we go,
Okay.
and I'll have to look at it and determine if that captures it. But yeah, I think those are the starting three. And I mean, I still think if we think we have a concern, the next question is going to be for price and bill information. So I mean, I think we're eventually going, if we think we have a problem, we're eventually going to get into that tedious exercise. Now maybe we don't need to have it up in front, but
Okay. Yeah, I would support going all the way, but if there is a big price concern, it sounds like we can get some minimal information. Well, I would say it's enhanced information to at least allow the staff to begin to proactively go after suppliers that are not, in fact, dropping after they've been notified. So,
I'll wait to see how this language shakes up. I am a bit worried that we are going beyond the requirements of the law in terms of harvesting all this additional data without additional resources. Mr. Fitzgerald.
Thanks, Mr. Chairman. Garrett Fitzgerald with Montgomery County. I agree with that statement that this would be going beyond the law in terms of the requirements that are stated in the reporting section specifically, and yet the statute also says that these suppliers cannot be charging more than SOS. I would strongly support the recommendations that Mr. Baker is making, that unless you're looking in some way at price or the total amount that's been billed, we're looking only at how many have been returned to SOS doesn't tell us whether or not folks are being charged more than SOS, whereas you can enable staff to actually see that if we're looking at that level of data. Maybe there's a way to do that where you're only looking at some sampling of data to try to minimize the administrative burden initially, so that we can all determine, is there a problem here? Is there a systemic problem here? Do we need to look at this for every single transaction that's happening, or is it possible that we can establish some standards here and that the industry will be in compliance? But I think we should expect that if there is no ongoing monitoring and verification of what's really happening on how much customers are being billed, that we're not really going to be in compliance. We all work in government. I obviously work in county government. We have regulations of all kinds as well. If there is no ongoing monitoring to enable effective enforcement, regulations are just pieces of paper. So we very much hope that you will follow the recommendation of Mr. Baker on this. Thanks.
Your Honor, if I may, I have made edits on the screen. What the edits have done is they've included A, which is directly from the statute. B now requires reporting of the notices that were sent to each supplier under the newly, and this notice is just for the newly enrolled in OHAP. And then C is the number of customers returned to SOS by each supplier within 1 week of a notice sent pursuant to that newly enrolled section. But just to be very, very clear, the straw man proposal didn't prevent staff from seeking any of this information. The straw man proposal simply required the utilities to record and then left full discretion to our technical staff and CAD to seek whatever information under their existing investigation authority to enforce the statute and do whatever they needed to. We can put this in regulation. We do not have to.
I was going to actually an option we might have is we could do this through order. I think it would be good for parties to know ahead of time of what we're going to want and not want. But if parties got together and determined what is feasible to collect, what's reasonable to collect ahead of time, instead of us doing this one on the fly, we know where you want to go, and if we know how you would like us to enforce, then we could go and structure reporting requirements around that if you thought that was appropriate.
Thank you. Well,
Sorry.
sorry,
I was just going to say, point is well taken with regard to order, because this all could have been done under an order. All of it.
from the beginning,
From the beginning.
by order or statute, is what started this ball rolling. Before we turn to you, Ms. Beckham, we will adjourn after we finish A. I recognize we have A, B, and C, and then we will be done. We're only going to get to A this evening. We'll save B and C for a date that I'll announce momentarily, but we will not be concluding today. Ms. Beckham.
So A sounds good, and then I guess, this is maybe just a preview for our next discussion. B, we're actually, that's not burdensome for us, because yes, we'll have that information regarding the notices sent to each supplier. The issue with C is, back to the original point, we won't know why these customers were returned to SOS. All the utility will see is the drop. So we again won't know if it was because the supplier received this notice from us and then dropped the customer. Again, it could be because the customer decided they no longer wanted to have this supply and they decided to go back to SOS off their own volition. We just simply won't be able to report that information. So just know that. And then again, with the within 1 week, it does add a level of complexity to the coding as well, which comes with costs, because needing to match up these customers with the suppliers, that's not currently in the system right now. So, but we don't have to, since we're not talking about B and C.
We're not. Ms. Knoll, where did 1 week come from?
We had a 5 business day requirement for the supplier to act, and so I simply gave them an extra day or 2. We could make it 10 business days, but we did put in regulation that they needed to take one of these 3 options within 5 business days.
Mr. Trout?
So, again, to discuss C that we're not discussing, I agree with Ms. Beckham that we can't track that, but if the goal is to match the number of notices sent by the utility to the number of drops pursuant to those notices that the supplier then makes, then if you ask the supplier, after you got a notice pursuant to B, how many times did you do a drop? The supplier can give you that information. So the staff can get that information. They just physically aren't able to get it from us because we can't see what the reason of the supplier, whereas the supplier can see it and can track it.
Mr. Trout, this is with regard to C. Charlie?
Yes, that we're not discussing.
Well, this C on the screen?
Yeah.
Okay, all right. And you're saying we should get this information from suppliers?
I'm saying that if you want to get the equivalent of C, you can get that, and the party that is able to give that to you would be the suppliers. And it'll be a nice matchup because they'll know how many notices they got, and then they know how many notices they acted on. In theory, the numbers will be the same. But anyway, they will know that. We won't.
Mr. Green? Will your members know the information in C? Mr. Trout doesn't want the utilities trading in this information.
So the supplier gets a notice. They have 5 business days to take action. If they should have the information that they got the notice with respect to this specific customer, and that they, what action they took if they dropped them within 5 business days. But I thought we should have the information, yes.
Okay.
Robert King for Washington Gas. I just wanted to note that we've been talking in the SCB, and in SCB we're adding a drop reason for the XML, which is probably just related to gas.
There will, yeah. So you're saying, you're recommending we leverage that? Okay, so
But-
there sometimes is a code that we could use.
Yeah, but not all suppliers are going to use supplier consolidated billing.
No, I mean, I think we could use similar language to accomplish it with all the suppliers, but that would require then everyone to do it.
I would propose that Commissioner Richard speak.
Okay. How could you tell I had? Ms. Peltier, you talked about this earlier today about since we didn't go with the drop, the required drop, that there would, we could take care of this with a reporting. Are we on the track that you had envisioned as far as the type of reporting that we should require so that our staff, OPC, would be able to pursue enforcement?
Thank you, Commissioner, for asking. And I'm just going to be completely honest. I would have to sit down with a piece of paper and model it out. It's trying, which I think we could do. It's taking the supplier enrollment report. It would require, though, a drop code. I'm just going to be upfront with you. I would have to sit down and model it out.
That's fine. I put you on the spot, but
No, I appreciate it.
It sounds
though.
like we do have extra time now to look at this and think about it. So
take it as an offline, and I will run my idea by using the current auto-generated monthly supplier enrollment report, and there might be a way by utility just to have another line item in there by utility of these types of drops. But can I get back to that?
Of course.
Thank you.
Well, thank you for coming up. Thank you, Mr. Chairman.
I would propose that we accept. Is that a two? Are we in two? Yeah, two.
We're in 2A.
I would propose that we adopt 2A and 2B, and that we park 2C under 3 and get back to that at a later date.
Sounds good.
No objection.
Your Honor, if I may, if we are adjourning, are there tasks you would like us to accomplish before we reconvene? Would you like offline discussion of these and a proposal to come from the group? There was not between last Thursday and today, but if these topics are better hashed out more.
Well, we're in the home stretch here. Obviously discussing reporting obligations of the suppliers and the utilities, and we'll see if, I know Mr. Green wasn't asking that 2C become one of his client's responsibilities, so we'll address that next week. The commission has made rulings. I don't plan on revisiting them when we reconvene. To the extent there are outstanding issues, I have some confusion. The parties may have some confusion. Use the next few days as an opportunity to see if you cannot reach consensus on any outstanding matters. Ms. Knoll, did you have anything in particular seeking guidance?
Mostly reporting requirements. For example, the A through F for the suppliers. But I don't think we can do that without going into that today.
That's right. We have to discuss them.
Correct.
Well, I mean, from my standpoint, I would be interested to hear, what is needed so we do have some ability to have proactive enforcement and proactive ability to look out for the interests of these OHEP customers. Particularly if we're not going to do automatic drops, we're going to have to take on that role here at the Commission, and OPC will probably also. So I think that kind of discussion would at least be beneficial to me when we come back.
So when I clean these up and I circulate to the parties, I will indicate to them that if they have red lines for these sections, they should provide them back to me to combine, or at least to have language so that we're not drafting on the fly the next time we reconvene.
And I would say if parties wish to have any last minute edits or modifications, to share them with Ms. Knoll before Monday. I would say I agree with Commissioner Richard that in a perfect world we should be proactive with respect to policing these markets. I believe that's one of our charge, and I believe that our compliance and enforcement unit under CAD is doing as good a job as they can under the resources that they have. At the same time, many of these reporting requirements, aside from the statutory requirements, are one step removed from what we need to do here at this rulemaking. I would love all this additional information, but we hear that it's going to come at a cost. Perhaps not a lot, perhaps a lot, both from suppliers and from from the utilities. I mean, we have this long list that we'll be addressing A through F. Some of this information may be readily available, some of it may not be. It's a concern as an agency head that we have the resources and we may not have the resources, and we'll be getting a lot of information if the wish list items here, and I'm not being flip or pejorative here, this is good information, and we would be able to match and determine if there's any problems along the way. But I'm also concerned that we're asking for a lot of information here, and we may not have the resources to process it.
Thank you, Chairman. I actually was going to say something similar. I agree with Commissioner Richards' perspective that it would be helpful to have information that allows us to make decisions about how proactive, whether to be proactive and how proactive. But it would be helpful to understand if we just include the requirements that are in the law in terms of reporting, what's missing in terms of being able to actually have a proactive enforcement approach, if anything.
So the only other thing I would add is that we keep in mind that some of these challenges will be transitional. On July 1st of next year, we'll have a number of challenges just with that first year of everybody trying to figure out what to do. But then 2 or 3 years from now, we'll be in a different situation. So we may not need regulations for every challenge that we see starting next year. We may need to think about the longer term regulations that we need here. And for some of the short term challenges, we may need to deal with that differently.
I guess since everybody else commented, I better say something too. Thank you for your hard work, one. Two, I appreciate the solicitation of additional information, but I'm reminded of the ancient Chinese proverb, be careful what you ask for, you might just get it. Have a good day.
The Commission will reconvene next Wednesday, November 9th, to conclude this rulemaking session. We will meet approximately 10 minutes after the conclusion of the administrative meeting. Do any parties foresee a concern of ability to participate? 1 week, 1 week from today.
Can you consult with your wife, Mr. Baker?
I'll ask her if she can wait a little longer.
Thank you all. We are in recess until next Wednesday, November 9th, after the administrative meeting.